Morning. I just wanted to do a sound and video check. I don't know if anyone's online yet.
Yep, I can hear you.
Great. Thank you so much.
No worries.
I will see you later on.
just checking you can hear me.
Yep, I can hear you.
Thanks so much.
No worries.
Good morning. Is the court reporter ready and the
Yes,
webcast
I
all
am.
set to go?
Yes,
Yeah, we're ready to go.
Okay, great. Thanks. Good morning, everybody. We're back on the record in proceeding 25A-0036E, Public Services Tariff on-bill financing proceeding. Before we get going, any preliminary matters to address? No? I think we are at Miss Elam. Before we actually do that, I think there are a couple people who maybe can be excused. Um, Mr. Fernandez, I don't believe for UCA has any um, cross, and I have no questions for Mr. Fernandez. So unless anybody has an issue, I think he can be dismissed. And I am not going to have any questions for EOC's witness, Alderton. So that witness can be dismissed as well. Are there any others? I think other than that, we're all good, right? Okay. With that, sorry, Miss Ilham, welcome.
Good morning.
And if you raise your right hand, do you swear to tell the truth, the whole truth, nothing but the truth?
I do.
And is anyone communicating with you or assisting you in any way?
No,
And if that changes, you'll let us know.
absolutely.
All right. Thank you, Ms. Elam and Ms. Stockmeyer.
Good morning, Commissioner. Good morning, Miss Elam. Could you please state your full name and spell your last name for the record?
Yes, it's Carolyn, Carolyn, Elam, Elam.
And Miss Elam, by whom are you employed and in what capacity?
I'm employed by the City of Boulder as a sustainability senior manager.
And did you cause to be filed in this testimony, answer testimony, and cross-answer testimony?
I did.
And that has already been submitted into the record. You have a correction to make to your answer testimony, hearing exhibit 800, is that correct?
That's correct.
If we could, I don't know who's driving this morning. Is that Miss Kunkel?
I think it's Miss Crane.
Miss Crane. Miss Crane, if you could please pull up out of Boulders, box.com, hearing exhibit 800, revised 1. Thank you very much. And Miss Elam, there are some, maybe we could just zoom out a little bit. There's some red lines markings on the first page, just noting that this is indeed Rev 1, and I believe it notes a little bit further down the date that it's corrected. Do you see that?
I do.
Okay, and if we could go to page 25, please, and at line 1, could you explain the correction that is made here?
Yes. So the correction that's made here is initially I was working off of memory and incorrectly represented the number of gas only customers. We've since gotten clarification from the company via discovery that the count is 440,000 gas customers. So this just corrects it to reflect the correct number of gas customers.
Okay, and are there any other changes in this testimony to your original that was filed and admitted into the record?
No, I don't believe so.
Okay, we would move to admit hearing exhibit 800 Rev 1 into the record.
Is there any objection? Seeing none, it's so admitted.
Thank you. And Miss Elam, if you were asked the questions that were in, oh, excuse me, Miss Crane, you can take this down, please. Thank you. If you were asked the questions that were in your answer and cross-answer testimony, would your answers be the same?
They would.
Okay. And there's just 2 more exhibits before I make you available that I raised at the beginning of hearing. One is if we could pull up hearing exhibit 802 from bouldersbox.com, please. Ms. Elam, is this an affidavit that you signed and had notarized regarding your testimony in this matter?
It is.
Okay. And I would like to move for the admission of hearing exhibit 802.
Any objections? No objections, it's admitted.
Thank you. And just lastly, if we could pull up hearing exhibit 803, please. And just scroll out a little bit so we can see the whole first page, please. Ms. Elam, what is this paper?
So this paper is a white paper that I cited in my testimony as a web link. And this is just the downloaded copy of that white paper. And it's a paper from the California Alternate Energy and Advanced Transportation Financing Authority that discusses interest rate buy downs and how they can complement private capital financing of energy efficiency projects.
And did you rely on this study to make recommendations in your testimony?
I did.
Okay. I would move for the admission of hearing exhibit 803.
Any objection? No objection, it's admitted.
Okay, thank you. And Ms. Elam is available for cross-examination and commissioner questions.
Okay, Mr. Smith, you're up.
Thank you, Commissioner. Good morning, Ms. Elam. I believe you and I have met before. It's good to see you again. Thank you for bearing with us as we get into a second day here. I promise I will not be too long, so we can. I know I'm the only one set to cross you today, so I'll try to keep it brief. For the record, my name is Ross Smith. I'm Assistant Attorney General representing trial staff in this proceeding. So I do have a couple of topics I just wanted to talk with you about this morning. Related first to the company's most recent DSM plan proceeding, and then the second is related to the idea of this interest rate buy down that I think has been talked about relatively extensively. Does that sound okay with you?
Yeah, that's great. And it's good to see you as well, Mr. Smith.
Thank you. So let's talk for just a minute about the company's most recent DSM plan proceeding, which is proceeding number 23A-0589EG. And we have the settlement agreement, but I don't think we need to pull it up yet. Are you familiar generally with this proceeding?
I am.
Okay. And as I recall in your answer and cross-answer testimony, you referenced this proceeding a few times. Is that right?
That's correct.
Okay. So then I assume you're fairly familiar with the settlement agreement that was signed in that proceeding, correct?
Yes, not word for word, but fairly familiar, yes.
Sure. And Boulder was a signatory to that settlement, right?
That's correct. Yes, we were.
Okay. And as with staff and numerous other parties that are represented here, right?
Correct.
Yeah, I actually think mine and Miss McLaughlin's names are on it. So it's fair to say you're fairly familiar, at least at a high level, with the established budgets for the company's DSM programs in that settlement.
Correct.
But I think you mentioned this in your testimony, but we can agree the settlement agreement did not contain a discrete budget line item for the on-bill financing program, correct?
Correct.
It required the company to file an application or advice letter to propose an on-bill financing program within 60 days of that proceeding being decided. Am I remembering that correctly?
That's my recollection as well. We subject to check, but yes, that's my recollection.
Okay. And the position that you stated in your cross-answer testimony is that the costs for this on-bill financing program were to be included based on the language that was in that settlement agreement, correct?
Yes, I think it's fair to say that going into the proceeding and in the test, I believe it was in the direct testimony of the company, there was clear expectation that within the term of the plan, an on-bill financing product was to be offered. And so I think it was very clear that that was not, that it was intended to be included within the budget of that program.
And in fact, in your cross answer, you actually say that this is really no different than any other implementation costs that the company would incur, right?
Correct.
Okay. And that includes if the program and implementation or administration costs cause the company to go above the budgetary cap that was agreed to in that settlement.
I'm sorry, can you restate that question?
Yeah, of course. Sorry, it was a little confusing.
As a discrete question, yeah, thank you.
So if your position in your testimony here is that if the program and implementation costs of the on-bill financing program were to cause the company to go beyond the established budgetary cap from the DSM proceeding, that would be okay in Boulder's position, right?
I don't think it would be our preference, but I think that nothing agreed upon in the settlement prohibited it from occurring if that were the case.
Okay. And at the least, Boulder's position is that it wouldn't warrant delay implementation of this program, right?
Correct.
Okay. And your understanding is that staff's recommendation regarding the DSM recovery, you do understand it's not to seek a delay of the program's implementation, correct?
I think there was maybe less clarity around that in reviewing answer testimony. I think from the staff witnesses cross yesterday, I think it's a little bit clear that that's not the proposal isn't to delay it.
Right.
So
yeah,
I would agree with you. I think that's gotten some clarity.
Okay. And so your understanding now is that it really staff's concern is to find the appropriate venue for cost recovery for costs associated, correct? Correct.
Provided,
okay.
Yeah, I think the distinction was whether or not that caused delay of the program implementation. That was my concern.
I see. And just to be clear, if the company were to exceed the agreed upon budget from the settlement agreement in that DSM proceeding, Boulder wouldn't view this as a material alteration of the settlement, correct?
From my perspective, no. I'm not a lawyer, but from my perspective, no.
Okay. So in your testimony, you also mentioned the company's clean heat plan, which was approved by the commission this year pursuant to another settlement agreement. Isn't that right?
There was no settlement agreement in the clean heat plan.
Okay. And but Boulder was a party to that
Correct.
proceeding, correct?
We were party to the proceeding, yes.
Okay. And in your cross answer on page 6, and I know we don't have to go there, but I'm trying to, if you need me to refresh, I can. You state that due to delays in the company's implementation of the clean heat plan, there's budget capacity to absorb the cost of the company allocating the program cost here to that budget. Do I have that right?
Yeah, I think as a clarification, I think between the two programs and because it provides benefit to both programs, we would support use of budget from either the DSM BE plan or the clean heat plan to implement the program.
Yeah, I see. And so like in the result of the clean heat plan, though, is that there's no provision that specifically regards using budget for the on-bill financing program from the clean heat plan, correct?
There's not a specific provision. There was certainly plenty of discussion within that proceeding about how an on-bill financing product could benefit uptake and delivery of the clean heat plan. So it was not unenvisioned in the proceeding. It was not explicitly called out.
And I see. But as I recall from your testimony, your argument is that it's actually critical to the implementation of the clean heat plan. Is that correct?
Correct.
Okay. And but in your testimony here, I believe you make that statement about it being critical to the implementation of the CHP, but you don't really expand on that statement in your testimony, correct?
I think I broadly discussed the barriers to energy efficiency adoption, and then by extension, I mean the targets in the clean heat plan require extensive adoption of DSM and BE measures. And so, yes, I think the two go together. I didn't explicitly expand on that by citing the targets in the clean heat plan, but I think it's reasonable to say that delivery of the DSM BE plan is already challenging enough for the company, and the incremental need called out in the clean heat plan certainly presents an even greater barrier.
Okay. And were you watching the proceeding yesterday?
I was.
Okay. And I believe at one point during Mr. Hyatt's cross-examination of company witness Murphy, he brought up the Mountain Energy project. Do you recall that?
I do recall that, yes.
And that's again that is currently being litigated before this commission. I know there's been some back and forth between council about that, so I'm not going to get into the details or ask you about the details. I'm asking just as a general matter, are you generally aware the company proposes to use unexpended clean heat plan funds in that proceeding?
That is my understanding. We're not a party to that particular proceeding, but I certainly saw that in Mr. Murphy's rebuttal.
Okay, so if that were to be approved, and if, let's say, if the commission were to approve on-bill financing costs come from the clean heat plan budget, does Boulder have any concern about using the clean heat plan as sort of a de facto clearinghouse for other budget shortfalls?
I think I would disagree with your characterization of budget shortfall. I think that there's plenty of room for the company to consider how it optimizes the way it is expanding both budgets, what it's putting towards marketing, what it's putting towards third-party implementers, what it's putting towards rebates, and what it would put towards tariff on bill financing. I think there's plenty of capacity within both budgets to make good choices from an efficient delivery perspective. That would be my perspective.
And there wouldn't be a concern about that representing any type of material alteration to the clean heat plan?
I think your use of the term material, I might be a little bit hanging up. I mean, I think we've
Sure.
talked about an administrative budget of roughly, I'm blanking on the number, but less than 1.5 million, and the clean heat plant budget is $440 million. So I wouldn't consider that a material change.
Sure.
Yeah.
But the clean heat plan budget didn't actually include any consideration of on-bill financing as part of a discrete line.
It was not explicitly called out, which I think is different than saying there was a discussion again within the proceeding. You can go back and listen to discussion as well as, review testimony. And I think the need for financing tools was very much considered within that plan. And I think understanding that the company from its strategic issues proceeding in the DSMDE case was clearly sending signals that an OBF product would become available in the timeline of the clean heat plan implementation. So I don't think it's mutually exclusive.
Okay. So I'd like to move on to my second and hopefully my last topic here so we can get you out of here. I'd like to discuss the proposal, this interest rate buy down proposal using the DSMCA. And as I understand it, that's a position that you've supported in testimony and that Boulder supports, correct?
Correct.
And in your answer testimony, not your cross answer, your answer, you recommend the commission authorize the use of DSMCA funds to buy down the interest rates of some or all of the measures approved for inclusion in the program. Do I have that right?
Correct.
Okay. And just for the record, DSMCA is the demand side management cost adjustment, just so we're all clear. I know we use a alphabet soup all the time, so
Yes, no, that's correct.
And you also acknowledge in your answer testimony that non-participating ratepayers may be affected by certain aspects of this on-bill financing program. So, for example, defaults by participating customers, correct?
Correct.
Okay. So going back to the DMCA issue, you acknowledge that DSMCA is paid by all residential ratepayers, isn't that right?
Residential and commercial, yes.
And that includes low-income ratepayers, right?
Correct.
So that means that a residential ratepayer, some of whom may be income qualified, many of whom are not, who choose not to participate in the on-bill financing program or can't afford to participate, would still be required to pay a portion of their bills to the DMCA for lowering the interest rates for ratepayers who could participate under this buy down.
Correct. Just as they pay for rebates and other implementation costs within the DSM programs, that would be true of TOBF as well. Correct.
Okay. And according to your testimony, Boulder considers these to be fairly minimal risks, correct?
Yes, fairly minimal risk. Yes.
Okay.
Correct.
But we can agree that minimal can be a subjective term, especially when we're considering impacts on low income qualified customers, right?
Correct.
So to your knowledge, has Boulder conducted any sort of in-depth analysis making clear what the risks to non-participating customers would be in the event the DMCA was used to buy down the interest rates?
So I would say it this way. We've certainly looked at other programs, default rates, and compared those to, for example, things like free ridership and rebate programs, and consider them to be on par or less in terms of cost impact to ratepayers. We've not proposed a specific means by which to buy down the interest rates. We certainly would support concepts like using a loan loss reserve to buy down the interest rate, more directly paying administrative costs to buy down the interest rates. Those would be preferable over, like a direct points buy down. But I think all those mechanisms are on the table. I think, as was exhaustively discussed yesterday, it's unfortunately that we can't have a conversation with CSEF to talk about which strategies are most effective. But I think our point is that we don't consider the current offer as it's presented to be sufficiently compelling, and we would like to see better interest rates. And I believe it can be done cost effectively, consistent with other implementation costs that the company incurs, as well as, like I said, there is no perfect rebate program in which we don't have some budget going towards things that are not of direct benefit. As long as they're cost effective, that would be the real litmus test.
And are you able to tell me what amount approximately of buy down would be required using the DSMCA to lower the interest rates to 0%?
I can't cite that. I believe one of the Western Resource Advocates, the witness for Western Resource Advocates, had one proposal in there. I think that we've considered, a potential 10% loan loss reserve on 25 million. That would be roughly 2.5. That would be the maximum at risk. Those are some of the numbers we have looked at.
But I think, as you mentioned, Boulder hasn't actually conducted that analysis, correct?
We've conducted that analysis. We haven't presented it explicitly in this case.
Okay. So just to return very briefly to this DSM plan discussion, I know that we've sort of belabored here. That settlement agreement that we talked about didn't contain any provisions related to using this DSMCA to buy down the interest rates for a future on-bill financing program, correct?
It didn't call for it explicitly, nor did it preclude it from occurring.
Okay. So as a signatory to that agreement, it's fair to say that Boulder's advocacy of an interest rate buy down indicate the belief that the approval of such a proposal is not a material change to that settlement agreement, correct?
Correct.
And I know I do share your frustration about CCF not having a witness present, Ms. Elam. So I'm just going to ask you very briefly, because we don't have anyone here to ask this question of. Are you familiar with the comments they filed in this proceeding on July 3rd as public comments?
I am.
And I'm not going to bring it up because I do not want to open that can of worms again. But there's also a letter floating around out there that I just don't want to have to go through again. And that was, are you familiar with both of those things?
I am, yes, that's fine.
Okay. And that CCF has apparently chosen to present this to the commission in lieu of proffering a witness for cross-examination or filing pre-file testimony. Is that correct?
Yes.
Okay. So in those comments, however, you're aware that CCF does not support the proposal of an interest rate buy down, as far as we understand, right?
Yeah, I think the challenge in what they represented is they aren't explicit as to whether they don't support any mechanisms to buy down the interest rate, or if they're simply referring to a strategy where you're buying down points. So I think we can't unpack that because, again, we can't discuss that with them. I would find it hard to believe that something like a loan loss would be something that they wouldn't support.
I see. And they state in there that they claim there are more economical options for reducing interest rates, I believe,
right.
some language.
And those would be the other two I've named, creating a loan loss or more directly paying their administrative costs. Because as I understand, both from their letter as well as the testimony from Mr. Murphy, the answer testimony from Mr. Murphy, they have ongoing administrative costs that they're seeking to recover through the interest rate. And so they need some certainty that their staff time is covered. I think a direct payment of their administrative cost is another way to buy down the interest rate. And so when they refer to more cost-effective ways, I suspect that's what they're referring to.
I see. So if let's say, since we can't ask them, obviously, whether or not the what exactly they have in mind. We know that they're opposed to the buy down option, despite the opposition from them. It's Boulder's position still to support an interest rate buy down, even if in the face of CCEF's objection.
Yeah, I think it should be explored, certainly. And I think that there's an optimization between how much money gets put in just a rebate versus what might get set aside in loan loss versus what might pick up administrative costs versus what buys down points. I think there's an optimization to be had. We've just not had the opportunity to fully unpack what's packed into the current interest rate that CSEP has included or what their assumptions are around ongoing program costs. But certainly, I think we can infer from the initial setup costs that it's less than $200,000 a year, since they quoted a $700,000 setup cost for the first 3 years.
And Boulder supports the interest rate buy down, again, even if that were to include that being paid by non-participants, correct?
Correct. As long as the portfolio of measures remains cost effective, yes, we think that would be in the public interest.
And potentially income qualified non-participants, correct?
Correct.
Thank you, Ms. Elam. I appreciate your time, Commissioner. I have no further questions, and good to see you again.
Good to see you as well, Mr. Ross. Thank you. Mr. Swiftly.
Thank you, Mr. Smith. Appreciate it. And good morning, Ms. Elam. I'm sorry, Ms. King, did you have some questions?
Yes, thank you. I know that I had previously waved across of Ms. Elam, but given her discussion with staff counsel, I wanted to clarify something in the record if I might have 10 minutes of time max.
Yep, go for it.
Thank you very much. Good morning, Ms. Elam. I'm Michelle King. We know one another, but it's nice to see you again.
Good to see you as well, Mrs. King.
I'm here on behalf of the Colorado energy consumers. If we can please pull from CEC's box, hearing exhibit 1203. And I would note that because this just arose, I'll have to update this exhibit with a proper header to the extent that it's admitted. Now, Ms. Elam, in your conversation with Mr. Smith on behalf of staff, you indicated you and he had a discussion about your interest in whether the company were to exceed its DSM budget in order to implement the on-bill financing program. Do you recall that discussion?
I do.
And I believe that it was your testimony, and of course, I'm not trying to put words in your mouth, but I believe it was your testimony that it wouldn't be your preference that the company exceed the budgetary cap in the DSM proceeding. Is that correct?
That's correct.
But if need be, you wouldn't have concerns about that. Is that right?
I think that what I said is I don't think that would be in conflict with the settlement and the terms.
Okay.
I think concerns, I would reserve judgment on what the proposal was.
Okay. Thank you for that clarification. Ms. Elam, do you recognize this document before you as the City of Boulder's responses to CEC's first set of discovery?
Yeah, if you could just scroll down for sure, but yeah, that's what it looks like.
And if we can scroll to the next page, please. And there is a question that asks whether the City of Boulder has objections or concerns with Public Service's decision not to seek incremental funding for the on-bill financing program, but rather to manage the budget for that within its DSM budget. Do you see that?
I do.
And it's your name as the sponsor of this discovery request?
That's correct.
I move the admission of hearing exhibit 1203. And in fact, in advance of Ms. Stockmeyer's objection, if we can scroll down to the subsequent request, please. And Ms. Elam, you are also the sponsor of CEC 1-2.
I am.
And if we can scroll to 3 and to 4, please. And you are the sponsor of these responses as well?
Yes,
I move the admission of exhibit 1203.
I think there was one more.
Oh, my apologies. 15. Is that your name as well, Ms. Elam?
Yes, yes, thank you.
Any
Hooray for doing this on the fly on a Friday.
any opposition?
No
I'm sorry.
objection from Boulder.
Okay, seeing no opposition, it's entered.
Okay, thank you. Now, with respect to CEC 1-5, you admit that the city of Boulder is a settling party, is that right?
Correct.
Okay, now we can take this exhibit down. And I believe it was your testimony that nothing in the settlement would be, that it wouldn't offend the settlement were public service to exceed the budgetary cap. Is that your recollection?
I think I would look to, I'm trying to think of how I stated it and the context of Mr. Smith's question at the time. I think that for the company to, his questions were around, you know, if the company were to propose something, is it in direct conflict with the settlement? And no, I don't believe it. The settlement explicitly precludes the company requesting authority to go above. I think the settlement was very clear, though, that there would be budget constraints with, you know, what was approved with regard to the budget, the flex authority. I'd have to go back and look at the specific terms of the settlement to remember the exact language in there. But I think those two things
Okay.
are different in my opinion.
Okay, so just so that we're speaking the same language, you believe that the company certainly can go up to the maximum of its flexibility authority. Is that right? Would it be helpful if we pull the settlement?
Yeah, I was going to say, I think at this moment, if I'm referring to the settlement explicitly, I'd like to look at what that is, which is different than
Absolutely.
what I'm thinking, which is, yes, I believe the company can request additional authority from the commission, and I don't believe they're precluded from doing so from the settlement.
Okay, so let's pull the settlement if we can. It's exhibit 1202. It's in
Ms. King, I
CEC's
would note that
files.
this is also already in the exhibit in Miss Elam's testimony.
The settlement agreement?
Yep. It's
Okay,
attached
sorry,
to
then I'm happy to use
CCE.
that instead, Miss. I'm happy to use that instead.
Well, if this is already up, it's attached with CCE 16, I believe. Yep. Or apologies. Apologies. CCE 13. There it is.
Thank you. And if we can please turn to page 4 of this document. And scroll down so that, yes, that's great. Thank you. And Ms. Elam, do you recognize what's provided before you on the screen as setting the parameters of the settling party's position with respect to approving the company's corrected electric energy efficiency budgets and savings?
I do.
And do you see in the fourth column from the left where it says plan budget? And the
Yes.
third column is the approved budget with flexibility. Do
Correct.
you see that? And so just so that we're clear, it is your testimony that the company can certainly ask for authority to get up to that $93.6 million cap. Is that correct?
Yeah, scroll down, please. I'd like to see the rest of this section to refresh my memory? Because I believe there's a 4.
I believe on,
Ms. Crane, could you just scroll down a little bit, please?
and I believe paragraph 4 that's before you
Yeah. So
is the settling party's acknowledgement of the treatment of that cap.
yeah. So this is this is the part that I was recalling in my response to Mr. Smith is it doesn't create additional restrictions on the use of budget flexibility beyond what is stated in the commission decision. So certainly it provides, yeah, some discretion to work within the flexibility as well as obviously retaining the discretion of the commission to work beyond what was in the settlement.
And where is that last point provided in this settlement?
Well, I think the commission always has the authority to make a decision different. So it's not
there's
called out in the
a-
settlement. I'm just simply saying that I think that discretion also remains irrespective of the settlement.
If there is an application seeking that authority, correct?
Correct.
And it's your testimony from the discovery response that the city of Boulder does not have concerns that the company has withdrawn that part of its request, correct?
Correct. It's remains as I mentioned to Mr. Smith originally. I think they have more than sufficient flexibility within the existing budgets, and it remains our preference that they work within them, which is different than if they were to propose something different, is there a reason that they can't?
And you recognize further that as a settling party, that the settlement is provided here in paragraph 4, that the company shall strive to adhere to the commission established caps and may use the authorized flexibility. So that's up to that 93.6 million, if
Yes.
and to the extent necessary, right?
Correct.
Thank you. Thanks for the extra time. I appreciate it. I have no further questions.
Thank you.
Thank you, Ms. King. All right, Ms. Elam, we're almost done here. I just had a few quick questions I wanted to get your perspectives on. First of all, I want to thank you for all the studies that you included in your testimony. That was really helpful. And I believe you brought up the notion of tariff on bill program in the DSM proceeding over 2 years ago. So
Yeah, it's actually, sadly, it's been like 5 years now.
So appreciate that. On page 8 of your testimony, you mentioned a series of recommendations. I believe many of them were adopted by the company in their rebuttal. With the exception of maybe some of the measures, for example, you said duct sealing and other envelope measures, they are included in the DSM program. Would they fall under the overall category of existing DSM measures, or would you go beyond those measures for really any type of envelope sealing, or is there any way we can specify that rather than just saying anything?
Yeah, I mean, I think that there are measures that the company currently rebates that are just wall and attic insulation and air sealing. And I believe that there could be additional measures that we know deliver savings, like duct sealing, like floor insulation, that may not be rebated, that I think are appropriate to include. I certainly wouldn't say, any kind of project that isn't at least also including the rebated measures. So I would just like to see it a little bit more expansive than what the company currently offers rebates for. Because we certainly see other utilities offer rebates for those measures, and just understand that the company does they don't quite pass their cost effectiveness test, which is different than saying they don't clearly deliver energy savings.
Right. And I mean, the cost effectiveness issue is a little different in this
Correct.
proceeding because we're talking about about measures that maybe don't include a rebate. So it's really just helping people be able to finance those measures if they wanted to do them on their home.
Correct. And you know, it's my preference that if you're getting, you know, an installation contractor in there to do some installation, that they, you know, do the balance of it, including, you know, where we certainly see some efficiency opportunity that's been untapped. So we would just like to see a more holistic project undertaken.
Is there is there a good way that the commission should identify those eligible measures as, you know, envelope sealing just in general, or
Yes, I think that would be fine, really, particularly, and I think the opportunity here is it compromises as long as it includes one or more measures that are the company is rebating. The balance of the envelope improvements can also be financed, I think would be helpful.
Okay, I see what you're saying. So if you're getting some sort of a rebated measure, but then while that contractor is in the home, they're doing some other work instead of itemizing out some what can be financed and what can't be financed, you just basically take that whole job and be able to
Correct.
finance it. That makes
Yeah.
sense.
Yeah.
Another thing you mentioned that the company responded to was the virtual calculator. And I think the company mentioned that they're interested in that. I think they mentioned that yesterday as well, but they don't have anything at this time. I was wondering if you're aware of any third parties who might be able to provide that service. I think CEO mentioned that Massachusetts in their testimony has something like that, but it's probably an in-house program. And I was wondering if you know of any third parties that, rather than, you know, creating it from whole cloth, that public service might be able
Yeah,
to.
I mean, I think that there's a few depending on what we're speaking to, but I'd certainly cite Platte River Power Authority. I believe they've implemented some calculators. I also believe that, and this is from recollection, and again, you know, I don't know exactly what CSEF has put forward as their offering to the company, but I also believe that there's some audit component or component of how they're implementing the program where they're presenting it. So part of this is just to make sure that if CSEP is not providing that, then the company provides something in addition to that. So I think my goal is just to ensure that there's something presented to the customer so they can make an informed decision. Yeah, and then, you know, certainly on the beneficial electrification, there's tools from Rewiring America. But yeah, I'd say, you know, Platte River Power Authority, I think even Tri-State actually has some calculators that are very helpful.
Okay, thank you.
Mhm.
So EECF in their letter mentioned that they aren't currently ready to provide small commercial, and I think that we've heard about a variety of different aspects that parties in the company are interested in, including HOAs, multifamily, renters, small commercial, where the intent is that a program would be expanded to include those, but they're not set up to do that immediately. Would you be supportive of that being something that was added, perhaps in the next summer's consolidated proceeding, if there were some sort of a phased-in approach?
Yeah, we're certainly comfortable with the phased-in approach. I think what would make me most comfortable if there was some, you know, certainty around timing or clear expectation around timing. I think as you and I spoke kind of at the initial, you know, our first settlement with the company, I think was in 2020 or 2021, where they would explore offering an OBF program, and here we are in 2025. So I think we would just be concerned about it languishing and not seeing clear action. So that would be my recommendation, is allow phasing, but provide some very clear expectation on how quickly that were to occur.
Okay. Um, The company referenced an extension of the terms to 15 years, but suggested that there would be a longer period maybe for qualification. I think they suggested 18 months as opposed to 12. Is that something that you support if you're going into a longer term beyond 10 years to 15 years?
Yeah, I had no concerns with that proposal.
Okay. Um, Number 15 on your recommended recommendations regarding consumer protections, you mentioned that for renters, you only be able to finance the amount minus the landlord's cost minus rebates. Are you talking about that for everyone or just renters? So the financing is going to the renter. How do they get the money from the landlord? What's the
Yeah, so, and this is specifically for the types of measures that I think under Colorado statute, landlords are clearly responsible for providing, which is space conditioning and water conditioning. So our concern is that you would have a situation where like the water heater goes out and 100% of the cost replacement falls on the renters then through an on-bill financing program. So I think in that situation, there would have to be a financial contribution from the landlord to stay consistent with statute. So I'm only concerned around the renter-landlord relationship and then specifically on those measures that they're statutorily required to provide. And it should already be built into the rent.
Okay, so somehow the renter would still need to get that money from the landlord, or the landlord would put money into the financed product.
Yeah,
Yeah.
or yeah. I think what we would typically see is that the landlord has the contractual relationship with the contractor that's installing the measure, but the financing is attached to the tenant through the meter.
Yeah, okay. Um, you mentioned in your recommendations the ability to have up to 5 deferrals for every 5 years, up to 80% of the life of the measure. The company described in their rebuttal the process EECF would go through to try and work with the customers. Um, do you think that that's an adequate process that they described in their rebuttal, or do you think there need to be more guidelines, or what do you recommend there?
Yeah, I think a lot of it is depends on the combination of tools. So the degree to which the financing is or is not subordinated to the utility costs. But I appreciate that there's the 90-day deferral. I think what wasn't as clear to me is how frequently that can be employed, and whether it can be scaled. And then I think we heard yesterday discussion that things like recasting the loan isn't off the table, but would come with an administrative cost. I'd certainly like to see that as a tool, so that let's just say somebody took out a 7-year financial term initially and can't and are now in financial constraints, and that monthly payment is too high. I would like to see the term be able to be extended to 15 years if it's a measure that's eligible for that.
Okay.
So those would be my recommendations, is to still have that expectation. I'm less tied to the how many times it can be deferred and over the course of the life, but I do think the ability to extend and recast the loan is something that should be an expectation.
Okay, thank you. So to the interest rate buy down paper, I think Ms. Stockmeyer just entered that into the record as hearing exhibit 803. So Ms. Crane, if you could bring that up and go to page 15. Hopefully I have my pages right. Great, thanks. And the first example is a $15,000 loan bought to 0%. and the cost of buying down that rate from 4.9. So obviously this is, going to be a little bit different in our case, but the cost of buying down that rate was $2,959. And so I did a little bit of, basic Excel payment formula math, nothing too crazy, but the payment is basically the same if you reduce the principal by 2,959 and charge the 4 point, whatever it is, 4.4, I can't really read it there, 4.9%, 4.4%. If you reduce the principal by 2,959 and charge 4.4%, or if you don't and you reduce the rate to 0%. And so in fact, it was so much the same that I kind of thought that's how maybe they calculated the buy down. But it was effectively the same payment. And then if you go to page 16, this is a shorter term loan, and a lower rate. The cost to finance the 0%, which in this case is $1,382, would actually lead to a lower payment when applied as a rebate at 2.9% or 2.99% than financing the full amount at 0%.
Commissioner, I apologize. Could Ms. Crane, would you be able to just scroll down a little bit so we can see the perfect? Thank you.
There you go. And yeah, you can read that. So I think the difference, was pretty substantial. I mean, if you have a 9,000 or $9,000 loan of payment was about 160, yeah, $162 a month. Buying down to zero with that $1,382 was $150 a month. But if you kept the 2.99 and just reduced your $9,000 that was owed by that same $1,382, so basically a rebate, your payment per month was $136, $137 a month. So about sort of in the middle there. And now, Miss Crane, if you could go to page 8. If you look down through these, and you can kind of scroll down through these various examples here, one of the things that is clear in this first graph in Massachusetts, in Connecticut, same experience. If you go down a little farther, clearly here in Rhode Island, over 50% said they wouldn't have financed if they hadn't gotten the 0% 0% interest loan. Michigan, similar result. So clearly, these various programs talk about the importance of 0% financing for investment decisions individually. So I'm wondering if you could maybe think about how we should think about this. Is it better to have a 0% rate because it drives participation in making these investment decisions, even where it might actually lead to a higher monthly payment? Or should we only have the 0%, for example, for longer term loans? It seems like the shorter loan is where the rebate is going to have your higher impact on your payment than longer term loans, obviously, because there's more interest. So in those cases, would it be smart for us to take the existing rebate amounts, apply them to the cost of the rate buy down rather than reducing the principal, in order to, reduce the costs that might take to buy down that rate, but because it's going to lead to a lower payment for those longer term loans? How should we think about this? I know that oftentimes, like, the economic decisions that people make aren't, necessarily driven by the actual economics, but more by sort of an impression. Oh, a 0% loan, I'm taking that. But the payment might actually be lower in using a different method. So I'm wondering, how do you think about that? And you can take down this exhibit, Ms. Green. How do you think about that? How should we think about that with respect to a 0% buy down versus a rebate for shorter term loans, et cetera?
Yeah, no, those are great questions, and I struggled with the same math you did. And kind of drew some of the same conclusions is, yeah, depending on how long the loan is, how big the rebate is, it certainly does adjust that monthly payment. I think the data though, and the surveys that are included there as well as elsewhere, is that the access to financing and low cost financing is very influential in customer decision making, far over the rebate. And so my recommendation is to get the interest rate as low as we can, preferentially, even if there's a slightly higher monthly payment, allow the customer to make that decision. The thing that I think we also don't fully understand, and I heard this yesterday, is, you know, the rebate does come later. It is something that you have to carry. And so, you know, I look at the current heat pump rebates, you know, over close to $7,000 for a 3-ton heat pump. That's a lot for somebody to carry. And so I do think, especially for those types of measures, 0% is going to be far more effective at driving participation and supporting those customers. I mean, I certainly support the idea of a higher interest rate for, you know, short-term loans or loans. Or sorry, I'm using loans, understanding these aren't loans, but for financing, you know, and maybe there's dollar thresholds as well. Where if it's a shorter term, smaller loan versus a longer term, higher loan, I think all of that's on the table. But my experience is, when presented, and people do this all the time buying cars, for example, whether they actually are saving money or not, they're going to take the 0% financing because they perceive it to be better. And because it's available, they're willing to make decisions that are like enhancements of what they would have done without that financing. So using my car example, they might get the features that they wanted that they wouldn't do if the interest rate was 4%.
Would it make sense? And again, I don't know if this is something that CCEF is able to do, or if there is a tool, if this was something that would be able to be you know, presented to the customer. But you know, basically market that the 0% financing is available, but then when the customer is trying to decide on what their finance option is going to be, allow them to choose. You can do it for 5 years with 5.9% financing, or whatever the number is. And this would be your payment, or you could do it, you know, for 5 years at 0% financing, and this would be your payment. Basically, give them a choice of one or the other. If you bought down to zero, of course, there would be the cost to the system, but it might not actually be their financial benefit. But at least then they're just making a choice based on the information of their options that are available to them.
Yeah, I mean, I think it obviously could add some administrative complexity, so just naming that, but I think there is a way to do it, at least in a simple way. Whereas, you know, you get the choice of taking the rebate and the financing at the offered rate, or foregoing the rebate and getting the 0%, and creating, you know, kind of an average kind of offering in that scenario where you know, where you're just presented with two, and it's not like, here's your payment here, or here's your payment, but leave it to the consumer to make a decision, because sometimes having the rebate up front is important to them, sometimes it's not. I will say this, I was a little concerned yesterday about how the rebate will get applied. to the financing. So it sounded like it just shortened the number of payments and not reduced the financing amount. So I think that would be something I'd want to get clear around as well, because it's not clear to me that the rebate is in fact lowering the monthly payment in the way we thought it was.
Yeah, that was a concern I had as well, and maybe the company can address this in their SOP, at least for clarification purposes, whether or not we're reducing the principal prior to the financing or reducing the principal after the financing. I think that's an important distinction, and whether or not that's something that they could figure out to do to the customer's benefit with CCEF. The last question I have for you is just more of a sort of a philosophical question I wanted to kind of get your thoughts on. So, I mean, historically, on-bill financing programs have really been focused on trying to make measures, number one, make measures more affordable for people. Number two, align what is a long-term savings with a longer-term payment. So you're not
Yes.
paying everything up front and then getting your savings over time, but you're kind of aligning those two things. And that's really focused on the individual and trying to address, individual constraints. I think that's been a historic way that on-bill financing programs have been, sort of treated and viewed. But we're getting also into a different sort of system where the customer and the building and the various different systems within that building are starting to play an increasingly more important role in the overall system. We've got virtual power plants. We've got battery management systems. We've got EV charging management systems, various different programs that are really looking to an aggregation of the customer base to try and address resource adequacy and to address peak demands, to address infrastructure and capacity constraints. And so as the company is looking at implementing this program, one of the things we've done is we've talked about incentivizing these rates for low-income customers, and that makes sense looking at it at the individual basis. But should there also be a focus on where there are the greatest capacity opportunities? For example, with AMI, maybe we can identify those areas where we have the highest energy intensity and be able to focus on those areas and use the incentivized buy down rate to try and get greater resource for the system in those areas. I just wanted to get your thoughts about that. How should we think about sort of a restructuring of these kind of programs with that changing dynamic?
Yeah, it's a great question. I mean, I can certainly see this as a tool for helping us make like non-pipeline alternative projects, as an example, more palatable, and easier to participate if you wanted to offer a, enhanced, like a standard rate at something better than the 5 to 6% presented, but like all customers get a 4%, but for this particular project where we see the value, we can monetize that value and buy the rate down to 0% and make it more attractive. I can certainly see that facilitating some of the, like you said, addressing some of the system constraints, incentivizing actions we need on a geographic basis. I can certainly see the value in that. I think my broader perspective, though, is I feel our rebate programs and our DSM programs and BE programs have largely left moderate to middle income households behind because the rebates just aren't driving the decision. So, I mean, this is really the tool I see as the priority to address that demographic. And make even just the base programs more equitable. So I wouldn't want to sacrifice trying to deliver the best product possible for that broad demographic, because since they've been paying into these programs for years and years and years, and they aren't served by, the high rebate income qualified programs, and they don't have the discretionary income of the people who historically take advantage of these programs. Like, those are the people first and foremost I want to serve, but certainly, I mean, I think this tool has broad benefit, and we could really leverage it in ways that will definitely make it easier to achieve public interests, right? Getting rid of that upfront cost for people, in my opinion, that's the biggest barrier to participation in any of the programs and driving the system benefits we need. If we can get solved for that, I think we can use this tool in many different ways.
Thank you. And I have no further questions. Ms. Stockmar, do you have a redirect?
Thank you, Commissioner. Just briefly, and I'll go backwards. I don't think I have any further follow-up to your discussion you just had with Commissioner Plant. I think that was helpful. I would like to start with just the discovery response that was admitted by Ms. King. And Ms. King, I apologize. I didn't catch the hearing exhibit number, and I don't see it yet in the shared box. It was the discovery response. Could you remind me what that hearing exhibit was, please?
Yes, actually, and I was planning to clean this up. When I had introduced it, I hadn't put the appropriate header on the document. And so I added it to CEC's box at that time as Exhibit 1203. However, because we didn't need to use our other designated exhibits, Commissioner Plant, if it's your pleasure, I think that we can rename it as a hearing exhibit 1200, just to avoid any gap in the sequencing. And I've done that and applied the appropriate header and have put that into CEC's box if we'd like to formally admit that and correct the record so that it reflects a more logical designation of number.
So admitted on the basis of logic. Thank you.
Thank you. So it's 1200, Ms. Stockmeyer.
Okay, thank you, Ms. King, and thank you, Ms. Crane, for pulling that up. And if we could go to page 2, the first question. Ms. Elam, I just wanted to clarify, this response you answered no to. The first line of the question refers to testimony of company witness Murphy. So I would like to go ahead and pull that up and then ask you a follow-up question. So if we could go to hearing exhibit 103, page 11, please. And that discovery response starts off referring to page 11, lines 1 to 5. And could you just briefly describe what the company has proposed here?
Yeah, so in this case, the company has indicated that they're no longer seeking this as incremental funding for the financing program based on what they presented in their direct case, which was the different components of the administrative cost. And so they've noted that they are proposing to recover the estimated costs of the program through their already existing approved budgets. That's what they've shifted their proposal to, yes.
And you've stated that it's Boulder's preference to recover program costs, but specifically, Boulder is supportive of administrative costs being collect the company's proposed administrative costs being collected through the existing plan. Is that correct?
That's correct.
So let's go back to your discovery response if we can. And if you could just clarify why you answered no to this in light of your testimony with staff and yeah, I'll just stop there.
Yeah, I mean, so the question is, do we object to their proposal to manage this within their budgets? That's consistent with our preference. And so I don't have concerns with their proposal, and I believe that they can manage it within their budget.
And to the extent that the company hasn't proposed any additional funds to buy down interest rates or create a loan loss, did you contemplate where those funds would come from in this response?
No.
And remind us where you think those funds can come from.
I think I cited in my testimony an opportunity to consider unexpended budget in the clean heat plan, approved clean heat plan budget.
And are there any other sources that you would consider?
Yes, I believe that the company can also shift budget it has identified, for example, for bonus rebates or marketing programs or other tools within their portfolio to improve the financing product and potentially drive the same or even higher participation rates at a lower cost.
And then we could pull this down, Ms. Crane, thank you. I just wanted to clarify, in your discussion with Mr. Smith, he asked you about interest rate buy down. You referenced a WRA witness. If I could just have us pull up hearing exhibit 500, attachment RA3, which is a testimony of sweeps witness, Ramon Altere, please. Alatore.
Oh yeah,
Ms.
apologies. I may have gotten the wrong witness. I just recalled seeing it. Yes.
Okay, Ms. Zima, I just wanted to clarify for the record if you were referring to sweeps witness testimony, and in particular, evidence that came through in this attachment.
Yes, I'm. Thank you for the reminder. It was sweep rather than WRA.
Okay, and if we could just quickly turn to page 11, please. And
Yes,
here
that's the table I was. Yeah, this is the table I was referring to.
Okay, and so based on this table, the estimated interest buy down for a program roughly 20 million, let's say coming from 7% would be roughly $10 million. Do you agree?
I agree.
And would that be over 1 year or over multiple years?
Yeah, in this case, it's showing a $20 million program, which is just slightly less than the company has indicated would be a 3-year program size. So over roughly 3 years.
So these numbers would be cut by third?
Correct.
Okay, thank you. And let me just quickly check. Oh, one more area, and we can take this down as well, please. You raised with Mr. Smith this idea. He asked you, I'm trying to remember his exact question. I don't want to misstate it, but have you done any analysis on the risk to non-participants? And you brought up a free ridership. And could you just describe what you meant by that?
Yeah, so when the company offers rebates for certain measures, there's a proportion where the rebate influences a customer decision, but there's also a portion of customers who would have made the same decision or are just getting the rebate. The best example, and then there's a portion where the rebate didn't deliver the savings that was accounted for. Either there was, a poor installation, or the installation had been removed. I think the best example is the old residential lighting program where the rebates went to discount lighting products in big box stores. Some of those lights were never installed. Some of them migrated out of the company's service territory. And so of the, for every 100 rebates issued, only, maybe 50 to 60% of those were actually credible savings to the company, but that still allowed and so that the ones that they couldn't take credit for were considered free riders to the program.
Okay, and were those products still approved by the commission as
Correct.
just and reasonable and in the public interest?
Yes, because they remained cost effective even with that consideration.
Okay, and how does that relate to defaults within the TOBF?
Yeah, so I think TOBF defaults could be considered not different than losses that come from free ridership. As long as losses do not reduce the cost or limit or make a product not cost effective. I think it's from a commission perspective, it's fair to consider it no differently than you do allowing for free ridership and rebate programs. I think it would be fair to say that this financing option is driving a very specific outcome and is probably far more attributable to delivering the savings than, say like a midstream rebate program.
And I just want to clarify one more point before I let you go. You're referring to cost effectiveness. How are you viewing cost effectiveness within the context of TOBF?
Yeah, so the TOBF is a tool to implement the DSM portfolio or BE portfolio. So within the portfolio, we have, like the heating and cooling product, which is where air source heat pumps, cold climate heat pumps are rebated out of. The cumulative costs of delivering the savings in that program is how the MTRC evaluates cost effectiveness. So as long as the money being spent is less than or equal to the system level, the monetary value of the system level benefits and the customer benefits, it's still cost effective, even if there is some proportion of investment that is lost as bad debt in this case.
All right, thank you, Ms. Ron. No more questions.
Thank you.
Thank you. So I think next up we have Ms. Laird from Clear. Good morning, Ms. Laird.
Good morning.
Mr. Platt, close
Yes.
to a break.
You need a break?
Yeah, it's about 10:30, just 5 minutes is fine for me. But I didn't know.
Okay, you got it. All right, let's go ahead and take a break until 10:30, so 13 minutes, and we'll come back with Ms. Laird.
Go ahead.
All right, we're back. Um, welcome back, Miss Laird. If you could hold up your right hand, do you swear to tell the truth, the whole truth, nothing but the truth?
I do.
And is anyone communicating with you or assisting you in any way?
No.
And if that changes, you'll let us know?
Yes.
Okay, it's all for you, Miss Judkins.
Good morning, Miss Laird.
Good morning.
Could you please state and spell your name for the record?
It's Alice Laird, ALICE LAIRD.
And by whom are you employed and what is your title?
I'm employed by Clear Clean Energy Economy for the region, and I'm the executive director.
And do you have before you hearing exhibits 1100 and 1102, which is the testimony you submitted in this proceeding?
I do.
And was this testimony prepared by you or under your direction?
Yes.
And if I asked you the same questions today as contained in that testimony, would your answers be the same?
Yes.
Ms. Laird is available for cross-examination.
Okay, I think we just have staff maybe, but Ms. McLaughlin, you're up.
Thank you, Commissioner Plant. And good morning, Ms. Laird. My name is Katie McLaughlin and I represent trial staff. I want to start today by talking to you about your understanding of the contract between CCEF and PSCO. So it's been discussed a lot, particularly yesterday. There was a lot of time spent on this. And I'm sure you're aware that the company and CCEF have yet to reach a final contract on the on-bill financing, correct?
Yes, I'm aware of that.
Have you seen any draft version of this contract?
I have not looked at it in detail. I have seen the letter that they sent that was discussed earlier today.
But you haven't seen a draft version of the contract between
I have-
CCEF and
I have
PSCO? Okay. And you'd agree with me that since this contract is not final, it's still subject to modification at this point.
Yes.
And in your cross answer, you discuss the on-bill finance program established between Tri-State and CCEF. Have you seen the contract between Tri-State and CCEF for the on-bill finance program?
I have not seen the contract. I've just seen the materials and the information.
So you would not be able to tell us how the contract between CCEF and Tri-State differs from the contract between CCEF and PSCO?
That's correct.
Okay. And is it your understanding that Tri-State's on-bill finance program is regulated by this commission?
I don't believe it is, but I should say I don't know for sure, but I don't believe it is.
Do you know what Tri-State activities this PUC regulates?
Not exactly.
Okay. So do you think that it's possible that an investor-owned utility like PSCO might have different incentives in implementing an on-bill finance program compared to a not-for-profit utility like Tri-State?
I can understand how there would be different incentives. I would share that our organization working on behalf of rural customers in Western Colorado is aware of these differences between Tri-State and PSCO and municipal utilities. And our interest is in helping all residents of Colorado, particularly rural residents, have more equitable access. So that's the standpoint we're coming from.
Okay. And is it your view that an unregulated on-bill financing program should set the standard for a regulated on-bill financing program before this commission?
Again, where Clear is coming from is we're looking at it through the eyes of what serves rural residents well.
Should the unregulated on-bill financing program set the standard for an unregulated one?
I guess I would say from our standpoint, it's more.
Objection, it calls for a legal conclusion.
It's overruled. You can give your best guess. Understand it's not legal.
Yeah, our perspective on this issue is that there are variations in how these utilities operate. We understand that. And from the standpoint of what serves rural residents and Colorado residents well. It would be great to have more equity.
Okay. Do you know where the funding is coming from to support CCEF and Tri-State's on-bill finance program?
Not exactly. I understand that some of it is from some external green bag funding.
Mm-hmm. Were you listening to the hearing yesterday?
I listened to part of it, but
Okay.
unfortunately not all of it.
No worries. It was a very long day, so I completely understand. Yesterday, during Commissioner Plant's questions of Mr. Murphy explained how Tri-State's program was using funding from the U.S. Department of Agriculture. And if we could please pull up what has been marked as Hearing Exhibit 702 in staff's box, please. And if we could please scroll to the title of this. Ms. Laird, this is a press release from CCEF from about a year ago describing its on-bill finance program with CCEF. And if we could please scroll to the second page, and I want to look at the middle of that page. I'm looking at a paragraph that starts with Tri-State and its members. If you could please read the first sentence to yourself of that paragraph, and if it is helpful, we can zoom in because I know sometimes these things can be quite small on the screen.
Yes, it would be helpful to zoom in. Thank you. And which paragraph are you referring to?
Yes, absolutely. So just in the middle of that page, it starts with Tri-State and its members.
Right.
If you could read that first sentence to yourself and let me know when you finished.
Yes.
Okay, so it appears that there's been $50 million in funding for the Tri-State on-bill finance program through CCEF. Would you agree with that?
Yes.
Okay, we can go ahead and take this exhibit down. Thank you so much. Now, do you recall how much funding CCEF secured in this proceeding for PSCO's on-bill finance program?
I don't know the exact amount what they have secured, but I know that the recommended budget was 15 million.
Let's go ahead and pull up the company's testimony. I think that would be really helpful. If you don't mind, that's going to be the rebuttal testimony of company witness Murphy, hearing exhibit 103. And I'd like to look at page 27, please. And specifically lines 4 through 10. And Ms. Laird, go ahead and read this and let me know when you have finished as well.
I've read that first part.
So would you agree with me that the company has secured $10 million in funding through CCEF?
Yes.
Okay, we can go ahead and take this exhibit down.
And then it does mention, can you clarify the 25 million?
Does this portion of the testimony provide any evidence that CCEF is able to provide 25 million?
Sorry, you're asking me that question?
Mm-hmm. You asked for a clarification on the 25 million.
I'm sorry, I'm not understanding your question.
Absolutely. So if you wouldn't mind taking a look at the lines 10 through 13, wouldn't you agree with me that this describes the company's desire to have funding at 25 million, but it does not describe CCEF's ability to provide that 25 million?
Yes.
Okay, we can go ahead and take this exhibit down. Thank you. And you'd agree with me that $50 million is 5 times more than $10 million.
That is correct.
And in your cross-answer testimony, you state that CLEAR believes PSCO's program budget should be increased to $100 million. Do I have that correct?
We're in support of SWEEP and other entities advocating for a larger budget that can better meet the demand.
And SWEEP recommends $100 million, right?
if I remember correctly.
Okay. Where does CLEAR anticipate that the additional $90 million will come from?
We did not, I will be honest, I'm not an expert on this. We did not go into exactly where that money would come from. We just know that there's great demand for this program and believe it would be a very, very important tool, especially for rural Colorado. And especially given that other sources of funding, such as federal grants that were providing rebates, have been frozen. So we simply stated from the standpoint of advocating for the need and the value of the program, that there is much greater need than a program that is on the lower range.
Last question on this topic. Is it your position that this commission has the authority to order CCEF to provide $100 million in funding?
Objection calls for legal conclusion regarding the commission's authority.
It's overruled. You can just give your opinion or knowledge on the matter.
We would not expect that the commission can require CCEF to provide that funding at all. We're coming at this more from the standpoint of the need and the value of this program and the desire to share that if other states are coming up with large pools of funding for on-bill financing, that there are multiple ways we think that could be mobilized. That said, I'm not prepared to give a really detailed answer on that. It's more of a policy-based, if other states are doing it, and this is a very important tool, could there be multiple sources of funding that we could look at? And also deferring to SWEEP's paper and their greater expertise on this topic, advocating for greater sources and being supportive of thinking expansively about this program.
Okay, thank you. So now I want to turn to the other topic that I would like to discuss with you today. In your cross answer, you support buying down interest rates for the program, correct?
That is correct, or some mechanism to have lowest possible interest rates.
And could you describe what funding CLEAR anticipates would be used to buy down those interest rates?
Again, it could be the USDA funding, or if some of the Green Bank funding does end up coming through. But there again, we are not an expert on the details of the financing. We came at this more from the standpoint of this would be of great value to rural residents, and low interest rates are very important. And then looking at other states like Massachusetts with their 0% Mass Save program. In addition, our rural co-op in the region, Holy Cross Electric, has 0% financing for heat pumps. So again, we're coming at this from the standpoint of if other states or other utilities are able to do this, let's think expansively about how to do it and have the lowest possible interest rates.
Okay. So were you present for Boulder's testimony earlier this morning, Ms. Elam?
I was.
And so you've heard that it's been discussed at this hearing and through pre-filed testimony that several parties are recommending that we use the DSM budget to buy down interest rates. Are you familiar with those arguments?
Yes, I heard that.
Okay. And you're familiar that the DSM budget flows through the DSMCA rider, right?
Correct.
Okay. And are you aware that the DSMCA rider applies to every single ratepayer's bill?
Yes, I believe so.
And that would mean that if residential ratepayers choose not to participate in an on-bill finance program, they would still be paying for it through the DSMCA rider, correct?
Correct.
And do you know how much money it would take to buy down interest rates to 0%?
I don't know exactly, and I was listening very carefully to that discussion this morning. It was very informative. Again, I am not an expert on the fine details of how this would be worked out. And we're coming at it more from the standpoint of what would be of great value to rural residents and helping them address energy costs and create a more equitable approach.
So just to confirm, Clear has not done any analysis on the cost that it would take to buy down interest rates.
We have not.
Okay. Is it your understanding that CCEF would welcome an interest rate buy down?
I don't know. I was reading through their letter this morning to understand that more. I would believe that they would be interested in any possible method to create the lowest interest rates possible.
And there's nobody here from CCF that I can ask those questions to, right?
It's my understanding they're not on this.
Okay.
Yeah.
Okay. So let's say the company were to try and use funds from the DSM budget to buy down interest rates. Do you know how much of that budget would be needed to buy down the interest rates?
I do not know.
Okay. And Clear intervened in the company's most recent DSM plan proceeding, correct?
That is correct.
And this ended up in a settlement agreement, correct?
Correct.
If we could please pull up what has been marked as 704. I think that it's already in the record at a different exhibit, but apologize, this is the easiest one I have access to. It is in staff's box. This is the settlement agreement from the company's most recent DSM, the 2024 to 2026 plan. If we could please scroll down to the bottom of page 29. Thank you. Whose signature appears on behalf of Clear for this settlement agreement?
That is me.
So fair to say that you're familiar with the established budgets for the company's DSM programs?
I have looked at this, but I do not have it memorized. That's correct.
No worries. I will not be asking you about the specifics, but just some generalized questions. We can go ahead and take this exhibit down, but we can agree that the DSM settlement did not include a discrete budget item for on-bill financing, correct?
That's correct.
And the settlement agreement simply required the company to propose an on-bill finance program.
That's correct.
Did any program budget in the DSM plan settlement include dedicated funds for buying down interest rates for an on-bill finance program?
I don't believe it did.
As a signatory to the DSM settlement, would Clear be opposed to using DSM funds for programs that are not specified in the settlement agreement?
I was listening very carefully to the last witness, Ms. Elam, and how Boulder, which is, we have long admired Boulder's programs on these topics and have learned a lot from them. And I would defer to the way she answered those questions. Again, we are not an expert on the very detailed aspects of the DSM program. And it was my understanding that her answer was there are ways to optimize how the funding is used. And we would be highly supportive of that. Given all the different measures in the DSM budget, on-bill financing is extremely, even though it wasn't included specifically, it's very important that it's being considered, and it is a very critical tool. And we would imagine that there would be ways to optimize the DSM budget to make it not only possible, but also very attractive, and started with when in our testimony, we said interest rates comparable to what the rural co-ops are offering. That said, Holy Cross Energy does have 0% financing for heat pumps. The other rural co-ops, I believe, say they're going to be, less than 5%. So to pull it back to your question, we would not purport to know the specifics of the DSM budget to know how much could be used for this. But in support of what Mrs. Elam said, we would believe that there are ways to optimize that funding to make this very important program both doable and very effective.
Okay, I have a couple follow-up questions on that answer. You mentioned Holy Cross having 0% interest rates on heat pumps. Is Holy Cross regulated by this PUC?
It is not.
Okay. So you also mentioned that you agree with some of what Boulder has said earlier, but I'm interested, as Clear was a signatory to the DSM settlement, what Clear's specific position would be about using funds for an on-bill finance program that was not specified in the settlement agreement, or a buy down for the on-bill finance that was not specified in the settlement.
But in general, on-bill financing is so important that we need to make sure that there's a way to make it happen. Again, as I said before, we don't know the very specifics of that DSM budget and would not purport to in any way say exactly what amount that is, but would just again support the other party's position that there could be ways to optimize that budget and tap other funding sources to make this possible.
Okay, I want to make sure that I have this clear. Is Clear, sorry for the double use of the, is Clear okay with using DSM budget funds to do a buy down for interest rates on an on-bill finance program?
Again, I would say we don't know the exact amount, and we are not an expert on the details of that DSM budget and what amount would be required to do the buy down. That said, it does seem like there could be ways to optimize those funding sources to help lower the interest rates. But beyond that, I don't want to purport to, we are not an expert on this topic. Again, we're advocating on behalf of how important on-bill financing would be as a tool, and especially important at this time, given that federal funding has been frozen, various rebate pools have been frozen. On-bill financing is such an important way to help people help themselves. And if there's any way that a portion of that DSM funding could help make the interest rates as attractive as possible, that would be highly desirable.
Ms. Laird, I apologize. I'm having a little bit of difficulty because I don't know that I've heard a yes or no on my question of whether Clear would be okay with using DSM funds to support a buy down.
Objection asked and answered. Also, Commissioner Plant, I'd like to point out that staff reserved 10 minutes for Ms. Laird. We are now looking at almost 20 minutes of questions from staff counsel, and would request that the questions be wrapped up.
Yeah, I think you've gotten about as far as you're going to get on this one, Ms. McLaughlin. So if you can move.
Okay. Then I have another question for you, Ms. Laird. If the on-bill finance program implementation and administrative costs cause the company to go above the budgetary cap of the DSM settlement, would Clear have a problem with that?
Again, I just want to keep being very clear that we are not experts on all the details of that DSM budget. So I don't want to give an offhand answer that says, yes, it's fine to go over the budget. We're coming at this from the standpoint of this program is very important and there must be ways to find funding for it. I don't want to be, I just need to be honest. We don't know exactly what we have not done the analysis to give a very specific answer on that question. In principle, this on-bill financing is very important, and there must be ways to, I'm probably overusing the word optimize, but optimize the various budgets to make it happen. But I would not feel comfortable giving a yes, it's fine to disregard that budget, because we simply haven't done the analysis.
Okay. Thank you, Ms. Laird. I have no further questions for you. I appreciate your time.
Thank you.
Thank you, Ms. McLaughlin. Ms. Judkins, do you have any redirect?
Yes, thank you. So good morning again, Ms. Laird. Do you recall when staff counsel asked you whether Tri-State's on-bill financing program should set the standard for public services?
I do remember that question.
And do you recall when Staff Council asked you about Holy Cross's on-bill financing program?
Yes, I remember that.
And are you an expert on public utility regulation?
Absolutely no.
But you would agree, right, that even if Tri-State and Holy Crosses and the company have different regulatory structures, that there could be lessons learned from Tri-State's and Holy Crosses programs that could be useful for the commission in ruling on this application.
Absolutely. So very, very important lessons to learn from the different utilities.
And do you recall when Staff Council showed you what appeared to be a news article that referenced the Tri-State on-bill financing program?
Yes.
And had you seen that news article before?
I have seen that picture. I have seen that article somewhere, but I have not read it or hadn't memorized it.
And given that you don't have a way to know whether what was stated in that article is accurate, right?
Right. I don't know.
And sorry, 1 second, let me consult my notes. And do you recall when Staff Council asked if CLEAR supported a program budget of $100 million that Sweeps Witness has proposed?
Yes.
And did CLEAR provide a specific number in your cross-answer testimony or your answer testimony regarding the program budget in this case?
I don't believe we did. We've been more along the lines of acknowledging that we are not an expert and wanting to advocate for the importance of this program, and in trying to acknowledge that we're not an expert, not overstate specific things, rather than be generally supportive that this needs to have more resources.
And did you support the suggestion or put forward the suggestion for a higher budget to make sure that whatever budget is available matches the likely customer demand?
Yes, that is correct.
Moving on to Staff Council's questions about interest rates. Is it your position that lower interest rates would be value to rural customers?
Lower interest rates are absolutely critical for this program to be workable for, I think, many people in the state, and particularly many of the rural customers that we interact with.
And you mentioned in your cross-answer testimony, I believe, maybe your answer testimony, that in the areas that CLEAR serves in Western Colorado, there are some places where neighbors on the same street might be served by different utilities, right?
That is absolutely correct. For example, in Carbondale, where I live, one part of town is served by Holy Cross Energy and another part of town is served by Excel. So you have people in one community being served by two utilities with very different incentives and opportunities. And it creates confusion, and it also raises the issue of equity, and in terms of what's good for the public interest and what works for advancing climate goals in Colorado. The wide disparity between what different utilities offer is problematic.
So it's CLEAR's position that it would be helpful both for customer confusion and for addressing equity issues that interest rates should be similar amongst utilities serving Colorado customers.
Absolutely. Interest rates and offerings.
And did CLEAR recommend a particular mechanism to fund interest buy down in your testimony?
We did not.
And did you intend to rely on the expertise of other parties and their recommendations when you supported lower interest rates in your testimony?
Absolutely. We really appreciate and value and continually learn from organizations like SWEEP, the City and County of Boulder, Denver, Our whole programs in the Western Slope have been aimed at how do we create the similar support systems that are offered, say, in the Denver metro area and Boulder. And we're not an expert. We're a very small nonprofit, and we heavily rely on the expertise of these other organizations.
Thank you. And then one final topic here. Do you recall when staff council asked you about the DSM-CA rider?
Yes.
And you explained your understanding that that rider is applied to the bills of all public service customers, right?
Yes.
So it's already the case that rural customers of public service pay the DMSCA rider, right?
That's correct.
And is it your belief that public service customers that live in rural parts of the company's service territory currently receive an equitable share of energy efficiency and other DSM programs?
It is not equitable. And when that question was asked, I thought of raising this issue, but every Excel customer is paying that amount. But due to various issues that we raised in the last proceeding and mentioned briefly in this testimony, the level of service delivery, awareness, contractor availability, a whole variety of things impact what rural customers are getting. So there's already issues of people paying into something and not necessarily receiving the benefit that, say, another geographic region may be receiving.
So you would agree that the application of the DMSCA may currently be inequitable as applied to rural customers, right?
Well, I want to clarify that we understand that you wouldn't want to have variations in terms of what people are paying. We need more attention to ensuring that the outcomes are equitable.
Thank you. I don't have any questions. Further questions?
Great, thank you very much. Sorry, and you excused Ms. Laird. Thank you.
Okay, thank you.
Thanks. Next up, we have, let me see, who we have next. For sweep, Mr. Alatorre. Welcome.
Thank you.
Can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Is anyone communicating with you or assisting you in any way?
They are not.
And if that changes, you'll let us know?
I will.
Okay, Mr. Hyatt.
Thank you, Commissioner. I see Ms. Crampton has her hand up, so I'll pause.
Thank you. Just before we get going, UCA will waive its cross of both Mr. Alatorre and Mr. Carley of WRA.
Okay, I believe that was maybe the only cross of Mr. Carley, and I don't have anything, so I think he can be dismissed.
Thank you, Commissioner.
Thanks. All right, go ahead.
All right, good morning, Mr. Alatorre. Can you please state and spell your name for the record?
Yes, my name is Ramon Alatorre. That's spelled R-A-M-O-N. The last name is A-L-A-T-O-R-R-E.
And are you testifying on behalf of the Southwest Energy Efficiency Project, or SWEEP, in this proceeding?
Yes.
Who are you employed by and in what capacity?
I am employed by the Southwest Energy Efficiency Project, or SWEEP. I am the Senior Program Manager in the Utility Program.
And did you file answer testimony in this case, which has been marked as Hearing Exhibit 500?
I did.
Hearing Exhibit 500 has already been admitted into evidence, and Mr. Alatorre is available for cross-examination.
Mr. Smith, you're up.
Thank you, Commissioner. Good afternoon, or still good morning, Mr. Alatorre. My name is Ross Smith. I'm an Assistant Attorney General representing trial staff this morning. Hoping not to take up too much of your time. I know we reserved 20 minutes, but I'll try to keep it under that if I can. So I'd like to ask first if Ms. Crane, I believe it is, to bring up your answer testimony, hearing exhibit 500, and go to page 16, please. Okay, so while we're doing that, I'd also like can we also bring up what's been marked in staff's box as hearing exhibit 705 and have that in a different tab? I want to avoid too much swapping around if I can help it. And Mr. Alatorre, do you recognize this exhibit?
Yes, I do.
This is the suite's response to staff discovery request CPUC 1-9, correct?
Correct.
And are you the signatory on this exhibit? We can scroll down
I
if we
am.
need to. Okay. And Commissioner, I would move that hearing exhibit 705 be admitted into evidence.
Any objection?
No objection.
All right, so admitted.
Thank you. Now, looking at this response, you state here that SWEEP has not had any discussions with CCF regarding fund availability. Am I reading that correctly?
That is correct. We have not had any conversations with CCEF.
And you also clarify that SWEEP has not conducted an analysis regarding the expected level of funding for the program after the initial 3-year period. Do I have that correct?
That's correct. Our analysis was based on this initial 3-year period.
Okay. And now, Ms. Crane, if we can go back to that Mr. Alatorre's testimony. And according to your testimony, do I have it right that SWEEP recommends the commission approve a $100 million program budget? Do I have that number correct?
That is our recommendation, yes.
And if we don't need to go back to it, but in that discovery response, you answer that SWEEP expects CCF to fund the full $100 million over the period, correct?
Yeah, when we made the recommendation for a program size, I think we were expecting that CCF or the capital provider would potentially be available to make it. I think we were speaking more about what has been available in terms of the questions of customer uptake and customer interest of compelling products in other jurisdictions. When making that recommendation on size, it was not based on any conversations with CCEF to be sort of intimately aware with their ability to have $100 million.
And so really, we don't know where SWEEP or where you can't tell me where SWEEP anticipates CCF obtaining the 90 million extra dollars beyond what it's committed, correct?
We don't have inside information about what is available to CCEF.
And as has been much maligned, CCF is not available here today to answering those questions, correct?
That's correct.
And just to be absolutely clear, the expectations that you've stated regarding the funding availability, those haven't been confirmed with the company either, correct?
That's correct.
And there's nothing in this record that would really provide any evidence as to that funding, correct?
Again, our recommendation was about sort of customer uptake and customer interest of similar compelling products, zero and low interest funds. We did not have conversations with capital providers or with the company to be able to understand what may be available, but we're providing recommendations and hoping perhaps that the commission will give guidance on the sort of scope of the program and the terms in terms of interest rate and capital amount made available.
Okay. And Ms. Crane, we can actually take these down for now. I don't really need them. I don't want them taking up everyone's screen. Mr. Alatorre, are you familiar with trial staff's answer testimony that's filed in this proceeding?
Familiar. I certainly have read once before.
Sure. I'm not going to ask you to give me exact numbers or anything from it or anything like that. I just want to make sure you're overall fairly familiar. And are you familiar with staff's concern that was raised, and I think a couple of other parties may have raised it, that there's a possibility that the program may actually create some financial hardships if a participant were to assume too much debt through the on-bill financing program?
I have heard some of those concerns, yes.
And we can agree that this program, if approved, would be an entirely new one to public service, right?
That's correct.
And we can also agree the commission has never approved a program like this before, correct?
I believe that's accurate.
So is it reasonable to say that really any new program may carry a certain level of risk of unintended consequences, right?
I suppose that's accurate.
And so it stands to reason then that if an on-bill financing program or any new program has a risk of unintended consequences, those consequences would likely be greater under a program with a $100 million budget than a $15 million budget, right?
I also think that the consequence in terms of meeting state policy and goals is significant if we're you know, underfunding programs that are meant to support achieving those goals. So I agree, a larger program potentially carries more risk, but a underfunded program carries different risks.
And those risks might include a greater burden for paying monthly bills, for instance, right?
Potentially.
Maybe a risk of unpaid bills that need to be recovered in a different way, right?
Potentially.
With this program, even potentially a risk of disconnection.
As the company has recommended and put forth.
Right. So, and I don't want to belabor this too much because we've already talked about it with 2 days worth of witnesses now. You're aware the company has not provided a signed copy of the contract reflecting the agreement it intends to enter with CCEF. Is that correct?
I'm aware.
And the company hasn't provided any draft document detailing the agreement it intends to make with CCEF.
I believe that's accurate.
In fact, the company's offered the argument that the contract either hasn't been signed and can't be provided, or alternatively that it doesn't need to be filed before this commission. Are you familiar with that argument that they're making, or two arguments?
I have heard those arguments.
And are you aware that one of trial staff's concerns in this proceeding is a lack of transparency regarding the financial arrangement the company proposes with CCF to fund this program?
You're with trial staff, so I will assume that is accurate.
Thank you. I appreciate the confidence. So I'd like to turn our attention to hearing Exhibit 700, Ms. Crane, which is Staff Witness Gebrez-Gabir's answer testimony. Might have gotten it right. Sorry, Nardos, if you're out there. And it's attachment NTG 8. I apologize, Ms. Crane. Oh, I'll give us a second. And just so we're clear, this has already been entered in. Oh, I'm sorry. This has been entered in the record as part of Ms. Gebrez-Gabir's answer testimony. And we talked about earlier. Have you had a chance to review hearing Exhibit 700? I know you said you're generally familiar. Have you had a chance to review?
I reviewed after it was filed.
And can we scroll down just a little bit, Ms. Crane, to the responses, please? There we go. Now, are you aware that CCF is only committing $10 million toward the launch of the program, and to staff's knowledge is working to expand the amount of proposed capital to $25 million? Are you aware of that?
I am aware by I guess subsection B there that it is the company's understanding that that is the case, but I have not had any conversations with CCEF to be able to understand whether that 10 million is the extent of what's available.
And I think you point out an important point, the company's understanding. But aside from these references here, are you aware of anything else in the record, either from your own testimony or any testimony that you've reviewed, that might substantiate the belief that CCF has the ability right now to fund more than what it is currently committing to in the record.
I don't have knowledge based on what is in testimony, but I also have not had an opportunity to speak with CSEF.
And Ms. Crane, we can take this down. Thank you. But it remains SWEEP's position that this commission has the authority to order the company and CCF potentially to provide an initial capital commitment of, according to your testimony, 10 times the currently committed amount and 4 times this proposed maximum proposed
I think the commission has the, I guess, authority or opportunity to communicate what it is that is their desire of TOBF offering, potentially in terms of size, in terms of rates. If the company or CCF is, unable to sort of meet those, then I don't. I think that leads to other conversations. But they've put forward an application and a certain amount of information, and I think it's reasonable to have conversations around capital amounts and interest rates and other things of that nature.
And we've just talked about it. We can't really identify where CCF may obtain this additional funding. Isn't that right?
I don't have inside knowledge about that.
Okay. And so is it fair to say that an amount, let's say, if we let's go with the $100 million example that we proposed, an amount that large would almost certainly require some additional funding source, right? That it wouldn't just come from CCF.
I wouldn't be able to say. I don't have inside knowledge about CCEF and
is it possible
availability, but potentially.
Is it possible that they would require federal funding?
I'm not sure. I want to speculate on where their funding may come from.
And we've discussed, I'm not sure, were you listening yesterday to Ms. McLaughlin, my colleague's cross of company witness Murphy?
I was tuned in all day yesterday, yes.
Great. Well, I'm sorry about that. There was a very brief line of questioning that Ms. McLaughlin asked Mr. Murphy regarding the greenhouse gas reduction funds. Do you recall any of that conversation?
I do.
And that those funds have been frozen and there's ongoing litigation around them?
I believe that is what the conversation was.
And is it also fair to say, I think we can say, obtaining additional federal funds under the current federal administration may present some difficulties that haven't necessarily been present in the past. Could you agree with that?
I think there's uncertainty when it comes to federal funds, though. I guess, as I mentioned, I wasn't speculating on where funding would potentially come in terms of the capital being provided.
And so I think then, because we can't get that information from the record, aren't we all really being asked to speculate as to where the funding is going to come from?
Suppose that's true.
I'd like to turn now to my next topic here, which is the interest rate buy down. And as I'm sure you are aware, it's because it has been mentioned several times, you're aware of what I'm referring to when I talk about the interest rate buy down, correct?
I am familiar, yes.
And SWEEP is a party that supports an interest rate buy down. Isn't that right?
That is correct.
And then I assume then that you're also familiar, if you were listening to my conversation earlier with Ms. Elam from the city of Boulder, there is a proposal out there to use the demand side management cost adjustment, the DSMCA rider, to use that to buy down those interest rates. Are you familiar with that?
Heard that as a conversation. I guess I'm not sure if any party is specifically proposing that.
Okay. Are you generally familiar with the DSMCA rider?
I am.
And are you aware then that rider applies to all residential ratepayers?
I'm aware.
And so that means that even if a residential ratepayer chooses not to participate in the on-bill financing program or can't participate, that would mean they would have a portion of their bills regardless going to buy down interest rates for program participants. Isn't that right?
And I think, as has been discussed, it's similar for whether or not a resident chooses to participate in a rebate program. But yes, I am aware that that is a proper characterization of non-participants.
And again, without belaboring the point, since I think we've discussed it already this morning at length, are you generally familiar with the company's most recent DSM plan proceeding?
I am.
And that settlement that was approved in that proceeding that I think has been brought up a few times now?
Yes, and I believe Sweep is a signatory.
You've already answered, you guessed my next question. That's great. And that agreement does not contain a discrete budget line item for an on-bill financing program, does it?
Not a discrete line item, no.
It does, nor does it include any provision authorizing the use of DSMCA funds to buy down interest rates as part of that program.
Not explicitly stated.
And despite it not being explicitly stated, Sweet's position remains that that the commission could and should authorize such a buy down, correct?
Sweep recommended a buy down. We specifically pointed to unspent clean heat funds. I think what Ms. Elam discussed this morning about both pots of money and potential appropriateness to consider whether or not to use funds from those sources. I found that compelling. I think we specifically mentioned, though, the unspent clean heat funds from 2024.
And did the clean heat plan decision, to your knowledge, include any discrete provision for OBF or the on-bill financing interest rate buydowns?
Not discrete.
And so if the commission were to authorize that here, whether it comes from the DSMCA, whether it comes from the clean heat plan unspent budget, Sweep would not view this as any type of modification either to the settlement agreement or as going outside of the scope of the decision in the clean heat plan proceedings, does it?
I think we see the use of those funds as being an appropriate use of those funds, especially as you mentioned, all residential customers are paying for both the DSMCA as well as the clean heat funds, and to put those funds towards a program that any resident could participate in would be, I think, appropriate use of funds, whether it's under the flexibility cap or whether it's considering how to use unspent funds.
And I believe that City of Boulder actually might have brought you into this. Are you able to provide me an estimate of what an amount of buy down would be necessary to reduce the interest rates to 0%?
I do believe that's in my testimony.
I think that's right.
Yeah,
I can bring it up if I need to, but are you able to give me an
for a $25 million program, as has been put forward by the company? I think it's somewhere ballpark between 1.5 and almost $3 million. And that's specifically for a points buy down, which is the type of analysis that Sweep did. I know there was also discussions about loan loss reserve, potentially buying or paying for some of the administrative costs. I think we would be open to all of that. We certainly did our analysis on a points buy down because I think it's illustrative of what may be required in order to get a zero and very low interest product. And if you were to consider a larger program like the 100 million that we recommended, then the numbers change. And if we were referring to the associated pages in my testimony, then I could say with a little bit more confidence what those numbers are.
Sure. And I rather than ask you to give me a breakdown of the analysis, do you happen to recall what those numbers would be at $100 million?
It's a range, I think, starting around $6 million over 3 years, potentially going into the mid $20 million over 6 years. And that, again, sort of depends on the mixture of loans that were at 5.99% in 3 years or 5.0% in 10 years. I think the the actual number would fall somewhere in between. Again, if it were a points buy down system on its own.
Okay, and I think we can actually go to if we can bring up your attachment RA3 to hearing exhibit 500 and go to page 11. I think that might help give us some clarity here. So I'm not just asking you to speak numbers into the void. Always helpful to see it, you know? And I'm sorry, Ms. Cran, I'm putting you through your paces this morning.
Sorry, what page is that again?
It would be page 11 to attachment RA3, and it should be table RA4 is, I believe, the numbering there.
I apologize. My robot vacuum cleaner is about to come in the room, so I'm going to go close the door.
Okay, that's perfectly all right.
Robots are already taking over.
They sure have.
So, Mr. Alatorre, I believe this is the illustration of what we were just discussing. Are you familiar with that?
I am familiar, yes.
So if I'm reading this correctly, it appears to me, and correct me if I'm wrong, that at $100 million, the buy down would be between $18 million and $50 million. Is that correct?
That is correct.
Okay.
Well, so I guess the way that you would look at this is for a $100 million program, if the interest rates that were, I suppose, being provided was 5%, and this is over 10 years, then to buy it down from 5% to 0% would be $38 million.
I see. Okay.
If
okay,
it was starting at 2% to go from 2% to 0% would be that $18 million.
Okay, I see. And that's more clear to me now. I appreciate that. And to be clear, the analysis you've conducted does not include an analysis on impacts to non-participating customers for an interest rate buy down, correct?
That's just the cost using a points buy down sort of methodology.
Okay, and we can take this down, Ms. Crane. Thank you very much. Sorry for the on the fly there. So with a buy down, just to make sure I've got this right, it's only borrowers that are benefiting from the 0% interest rates, as opposed to, let's say, rebate funds, which can be distributed among all eligible customers. Isn't that right?
I mean, I think rebate funds are only being collected by participants. So I would say it's the same that borrowers are participants in the TOBF program.
And so just, are you able to tell me what the potential cost would be for non-participants?
I'm not sure I understand the exact nature of your question. It would be, that amount of money would be sort of what is required in order to buy down the rates. So similar to collecting money in order to be able to offer rebates and other incentives. That is the cost to the pool, and then participants get to take advantage, and non-participants get the benefits of energy efficiency on the system.
And are you able to tell me what the bill increase would be on average for a non-participant if there was a buy down?
I mean, I think we've recommended using unspent funds, so I'm not sure that there's any potential impact, but in future proceedings, if the commission were interested in continuing to provide guidance to continue buying down rates, then there would probably be continued analysis done to evaluate current programs and the costs required in order to buy down rates, and that would have an impact either on the DSMCA or the CHP or otherwise. But at this time, I don't believe that our recommendation chain has a material or impact on either of those already approved cost recovery mechanisms.
And would you agree with me that the rebates and benefits and the impacts have been fully assessed in a DSMBE application, while on-bill financing, those benefits impacts have not been assessed for cost effectiveness?
I believe that that is a reasonable characterization.
And
I would also say that my testimony was demonstrating how using money for TOBF, buying down interest rates, it's fundamentally an efficient use of funds. We were mentioning be able to show how for every dollar that's being put towards towards being able to provide zero and low cost financing, you might be able to support something like 2.5 to 13 times as many like heat pump installations, for example. So I think we find it to be a fundamentally efficient use of funds to be able to provide low cost financing as opposed to rebates alone.
Sure. So just as to wrap up this line of questioning, you aren't really able to tell me what burden may ultimately be borne by non-participants, which includes some income qualified customers, correct?
I'm going to object. This has been asked and answered, and similar to the past witness, staff reserved 20 minutes of cross time, and I think we're approaching 27 minutes soon.
Yeah, we could try and either get to the point or move on there.
Sure, I can do that. I just would like an answer to the question of yes or no. And I can repeat it if you'd like.
I have to hear it restated, but I don't think it's any different than what I've said so far.
Sure. Sitting here today, you cannot tell this commission how much of an increase the company's ratepayers would expect to cover for the cost of buying down interest rates for financing home upgrades for other ratepayers. Yes or no?
I don't believe there would be an increase based on SWEEP's recommendation to use unspent CHP funds.
Sure. I'll try to wrap this up since I know I'm running on time. Have you reviewed the comments filed by CCF in this proceeding on July 3rd? I'm not going to bring them up, but do you recall that?
Yes.
And are you aware that CCF does not support an interest rate buy down?
I am aware of that.
Okay. The last thing I want to just discuss is in your testimony, you compare the per capita financing for 3 separate states, Massachusetts, Connecticut, and Colorado, I believe. Is that correct?
I think we have one table that includes New York, and then other tables that end up going to Massachusetts, Connecticut, and Colorado.
Okay, and if we bring up your answer testimony at hearing exhibit 500 at page 16 and on line 11, please, Ms. Crane. And I promise I am almost done. So on line 11 down here, Ms. Crane, if you could scroll down, please. You state that the company's proposed $25 million, the company's proposed $25 billion is far less ambitious than those in Massachusetts or Connecticut. Is that correct?
That's correct.
Okay. Now, I just would like a little bit of clarification for the record about the comparisons you've made between these programs. Is the use of a per capita metric here intended to provide an estimate and comparison of customer interest or customer uptake between Massachusetts, Connecticut, and the proposal here in Colorado?
I guess it's a population normalization. Massachusetts has twice as many people approximately as are in the Excel service territory. So to say that Excel should be striving for the same dollar figure as them didn't make sense, I think. So we normalized based on population of the relevant either service area or state, and then that's where some of these numbers come from, is after we've done that normalization.
But that doesn't necessarily take into account details of how the programs were implemented, correct?
Correct. That's why we were recommending that the details be similar to Massachusetts or Connecticut, with zero and very low cost financing, and that has been found to be an incredibly compelling product in those jurisdictions. And if a similarly compelling product were to be made available in the Excel service territory, then we think it's reasonable to expect similar interest and similar uptake.
And you would agree with me that the programs offered in these states that are being compared are programmatically different from each other and different from what's being proposed here, correct? Potentially.
That's correct. There's differences, and we were recommending that changes be made to this program so that they more closely reflect some of those differences that we think do make an impact on interest and uptake.
And when you agree that it really makes logical sense to consider the availability of funds and program specifics prior to making a determination of the level of customer interest, right? Otherwise, how would a customer even know what they're interested
in? Could you restate that question?
Yeah, you would agree that it's important to consider the availability of funds and program specifics prior to making a determination of the level of customer interest, correct?
I think that the size of the program, the interest rates, yeah, all of those details should be ironed out. And if a sufficiently compelling product is made available, we've demonstrated that there is high interest and uptake in other jurisdictions.
Okay. And you would agree that considerations of funding availability and these programs specific generally should precede conclusions about the ambitiousness of programs, correct? Otherwise, how do we know how to judge ambitiousness, right?
I think you could have ambitions that guide your decisions in terms of capital amount made available and the interest rate. So I suppose the interests and ambitions of either the company or the commission could guide some of those programmatic details.
Okay, and I'm going to move on, but my last line of questions here, very short. Again, referring to your analysis of other utility-run financing programs, you conducted that kind of analysis, correct, including on the Massachusetts Heat Loan Program?
That's correct.
And my understanding is that that provides over $200 million per year in financing to customers in Massachusetts. Do I have that right?
It's about right.
And am I understanding correctly that that program relies on local lenders to offer consistent financing product directly to customers, right? So it's a little bit different.
It is a little bit different. It's using utility funds in order to buy down interest rates. But correct, all three of the programs that were cited in the sweep study, have slight differences.
And in those studies, the programs available, for instance, in Connecticut and New York, they've been funding around $50 million per year in financing. Is that correct?
Sounds directionally correct, but without referring to the table, I would have to check.
And are you able to tell me how long those programs have been in place?
I cannot tell you that today.
Okay. And just on the Massachusetts heat loan program, you refer to it as the largest of the utility run programs that you looked at by far. Is that fair?
That's correct.
And again, though, you didn't conduct or assess how much initial capital was provided at the initiation of that program, right?
We did not look at program origination and initiation about that program.
And I don't want to ask you too much about it, but subject to check, you would agree that the Massachusetts Heat Loan Program started roughly 19 years ago in 2006. Is that right?
If you've checked that, then I'll assume that you've done your research well.
And you're aware so you can't tell me what the initial capital that was available when that program launched in 2006, right?
That's correct.
Okay. If I were to tell you that it was $5 million, would you have a reason to dispute that?
I do not.
Okay. So just to wrap this up, but as far as you can tell, we're talking about potentially very different levels of initial funding, and that the Massachusetts HEAT program was part of legislation, right? It was as a result of legislation passed by the Massachusetts legislature.
These are not some of the details that were included in our analysis. I think there's also an element of if other utilities, including the mass heat program, have been, providing an example for 19 years. We don't necessarily need to start at square zero where they were. There's an opportunity to learn from lessons and not necessarily need to take 19 years to get to the same point.
But doesn't that reveal an inherent challenge in making equivalencies between two such different programs?
I think it's reasonable to look at what is happening in other areas and to have conversations around program design to be able to have the TOBF program sort of serve the purpose that I believe Commission has been hoping that it would for over a decade, as well as other stakeholders. So, $8 million a year, roughly. If we're talking about the 25 over 3 years, sort of is lacking in ambition compared to what has been demonstrated in other jurisdictions if a sufficiently compelling product is made available.
And we can agree then, as the final thing here, that the $100 million proposal very likely is based on what we can assume here. It's orders of magnitude higher than what these other programs were initially funded with at their outset, correct?
I have not done that analysis.
Okay. Well, once again, I sincerely appreciate your patience. Chair, Mr. Hyde, I appreciate your patience as well. I know I went over time and apologize for that. Mr. Alatorre, I appreciate your testimony and for talking with me, and hope you have a good, wonderful rest of your week. I have no further questions.
Thank you, Mr. Smith. Mr. Hyatt, redirect.
Thank you. I do have some questions. So, Mr. Alatorre, let's start with the issue of buying down interest rates. Do you recall that Mr. Smith brought up attachment RA3 to your testimony, which was the report sweep conducted regarding on-bill financing?
I recall that, yes.
And he brought up a table showing the cost to buy down interest rates, didn't he?
Yes.
So that sweep report, did that look at the overall on-bill financing opportunity in Colorado?
Both in Colorado and in the Excel service territory.
Okay. If we could please pull up now here in Exhibit 500, just Mr. Alatorre's answer testimony. If we could go to page 22, please. Thank you. Scroll down so we can see that full table. So, Mr. Alatorre, in your answer testimony and your work in this proceeding, did you analyze the cost to buy down interest rates specific to what PSCO has proposed in this case? And is that represented in table RA5 here?
I did, and it is represented in that table there.
Okay. So Mr. Smith asked you some questions about how much it would cost to buy down the interest rates for a $100 million program. Do you recall that?
I do.
Does this table show that based on your analysis specific to this proceeding, it will cost between approximately $7.5 million to about $27.1 million to buy down interest rates to zero for all customers?
Yes, thank you for bringing up this table.
That's
what it shows.
Thank you. Does this table also show that as far as what the company has proposed in a $25 million program size, it would cost between about $1.9 million to about $6.8 million to buy down interest rates to zero for all customers?
It does show that.
And is it SWEEP's proposal in this case to buy down interest rates to zero for IQ and DI customers?
That is our recommendation.
And then for customers who are not IQ or DI customers, what is SWEEP's recommendation for what the interest rate buy down should be? What should be the interest rate for those customers?
SWEEP recommended 0.99% financing for market rate.
Thank you. Related to interest rate buy downs, do you recall a series of questions from Mr. Smith about the bill impacts to non-participants of buying down interest rates?
I do.
And did you generally answer that there would be no bill impacts for non-participating customers?
Based on SWEEP's recommendation to use unspent CHP funds, I don't believe there would be new incremental funds at play.
So why would SWEEP's proposal to use this unspent clean heat funds mean there would be no bill impacts to non-participating customers?
I believe because they were already approved and being collected as a result of the clean heat plan.
Okay, let's switch topics now to the beginning of your cross-examination and the series of questions about the overall program size as far as SWEEP's recommendation for a $100 million program. Do you recall that series of questions?
I do.
And do you recall Mr. Smith's question suggesting there's no evidence in the record that would support the ability of CSEF or the company to fund a $100 million program?
I do.
Okay, if we could please now pull up here in Exhibit 103, which is Mr. Murphy's rebuttal testimony. Thank you. If we could go to page 26, I believe. If we could scroll down. Thank you. So, Mr. Alatorre, can you just read for yourself real quickly the sentence? It begins on line 19 here. Actually, two sentences. It begins on line 19 saying in particular, and then read through to the end of that page.
I've read it.
Thank you. So at last sentence on lines 22 to 23, doesn't this state that CSEF is actively raising additional capital to support further scaling?
It does.
And as you read that, do you interpret that as stating there's any maximum amount of capital that CSEF could raise?
I would not be able to intuit that from this sentence.
All right.
Unclear.
So in SWEEP's view, why would it be more reasonable for the commission to approve a $100 million program versus a $25 million program?
I think we've shown that with compelling terms, customer interest, customer uptake will be there. And we're looking for this type of program and have been for years, if not decades, to support our state policy goals. At 25 million over 3 years, I think we're sort of lacking in ambition, and we're aiming to really meet our clean heat targets, our DSMBE targets, and program that is sized accordingly gives us a much better chance at being successful in achieving our policy goals.
And do you recall a related series of questions from Mr. Smith about, I think you phrased it, the risks of unintended consequences with a larger $100 million program?
I do.
In your view, are there any risk or unintended consequences if the company implements an inaugural on-bill financing program that is insufficient, has not enough capital to meet customer interest?
I do think there are risks to that. Yes.
And what are some of those risks or unintended consequences of that scenario?
Potentially failure to launch if there's if the product that's brought forward is not compelling, then we may find ourselves, a few years from now trying to rehabilitate a program that didn't have compelling terms, didn't have sufficient capital, and that would be sort of an unfortunate situation to find ourselves in.
Okay, and last topic, real quick. Do you recall the series of questions from Mr. Smith about the uncertainty of federal funding that CSEF may or may not be able to obtain?
I do recall that conversation.
Since you filed your answer testimony in this case in late May, has there been increased uncertainty regarding federal rebates for customers who may want to install eligible measures under this program?
I'm not entirely sure. I know that the uncertainty in the most recent reconciliation bill have made things continue to be uncertain, but I don't know if it's more or less uncertain than when I filed testimony, and am honestly needing to get up to speed on some of that myself.
Okay. And if there is generally uncertainty regarding the future of federal rebates for customers for eligible measures, in your view, how should the commission think about that as far as the need and the size of an on-bill financing program?
And I am just going to lodge an objection that my cross did not include questions about customer rebates uncertainty. I was asking specifically about funding to CCEF, federal funding. So I would just like to lodge that objection.
If I may respond, I think this is just the flip side of the coin of federal uncertainty and how it impacts this case. So I think it's within the scope of his questions and a fair line of questions for redirect.
I'll allow it and continue.
I guess I would generally characterize the uncertainty at the federal level as highlighting the importance of more local action, whether it's at the state level, utility provided programs, and otherwise.
Thank you, Mr. Alatorre. That's all the questions I have.
Thank you.
Thank you, Mr. Alatorre and Mr. Hyatt. Next up, we've got Mr. Kuykendall from UCA. Hello, Mr. Kuykendall. How are you doing?
Good.
Just making it in under the wire for good morning. Can you put up your right hand, and do you swear to tell the whole truth, nothing but the truth, the whole truth, and nothing but the truth?
I do.
And is anyone communicating with you or assisting you in any way?
No,
And if that changes, you'll let us know.
I will.
Okay, Ms. Crampton.
Thank you. Good morning, Mr. Kuykendall. If you could just state where it is that you are employed and what your role is there.
I am employed for the Utility Consumer Advocate, and I am a rate and financial analyst.
Okay. And in this proceeding, did you draft and file what's been marked as Hearing Exhibit 301, Answer Testimony of Carrie Kuykendall?
I did.
And if I were to ask you the questions that are posed in that answer testimony today, would your answers be the same?
They would.
Thank you. Mr. Kuykendall is available for cross-examination.
Thank you. Ms. Berman for clear.
Thank you. Hi, Mr. Kuykendall. For the record, I'm Sarah Berman representing CLEAR. And I'd first like to focus my questions on UCA's stance that approval of the TOBF program is premature. So first, UCA does not altogether oppose the company's TOBF program in light of the Commission's stated interest in on-bill financing. Is that correct?
Yeah, we support wholeheartedly the idea of on-bill financing. We just think that it should be done correct.
Thank you. In your testimony, you stated that UCA supports the idea of a TOBF program to help customers defray the costs associated with products that are available to achieve demand-side management and beneficial electrification objectives, right?
Right.
But UCA is concerned that it is premature for the interveners and the Commission to evaluate whether the program proposal is in the public interest. Is that correct?
That's correct. And based on everything we've heard in this proceeding, there really was very little preliminary work done in presenting this and bringing it, getting the filing ready. And so there were so many questions, especially, after answer testimony was filed. So our conclusion was that, yeah, it was premature and needed to be vetted a little more.
And you recommend that the Commission order the company to resubmit the proposal when there are enough details to warrant substantive discussion. Is that right?
That's correct.
Is it your opinion that the details required for the company's TOBF program could be addressed in the current proceeding, or that these details can only be addressed in a new proposal submission?
Well, I think that really when looking at the TOBF proposal, the devil is in the details. And to really address those details in a piecemeal fashion, the way it's been done, is really not, I think, in the public interest. When answer testimony was first presented, we didn't know anything about how interest rates were going to be changed, if they can be changed. We didn't know which appliances would be offered or can be financed under. We didn't know a lot of things. And then as in rebuttal, those more and the details have come out, and really we've had a little time to try and analyze those things, and there's still a lot of different questions. And so to do it piecemeal like this, I don't think really achieves what we would consider would be in the public interest. So I don't think that this process really is the correct way to go. It's better to just, file it when we have, more of the meat on the bones, if you will.
Thank you. So the commission could approve the TOBF program now with instructions to the company to address those piecemeal details that you mentioned in its implementation.
They could, but there are some things that I think that need to really be fleshed out by the commission before they approve this. I think that there are things, for example, the interest rate changes. We don't know how the interest rates are going to affect or impact people in their bills. We don't know how the average customer is going to, are their bills going to increase or decrease based on this financing model when considering the fact that there's going to be higher electric usage as a result. And so we haven't really analyzed those. We haven't even taken a look at really, are there going to be increases for the average customer? So there are a lot of things that still need to be ironed out, I think, before making a final decision.
Understood. Thank you. Now turning to a couple of questions about renter participation. Are you familiar with the company's proposal to phase renters into the program?
Yes, I am.
And once renters are included, the program will only allow renters to participate if the property owner arranges the work and signs documents for participation, correct?
Correct.
And UCA opposes the proposal to allow renters to apply for the TOBF program, right?
That's correct. We believe that really the ultimate responsibility is going to be on the homeowner and should be on the homeowner, whether it be a landlord or whether it be someone who is living in the home. They should approve the work and be involved in approving the work and signing the paperwork in order to have the work done.
Understood. Thank you. Are you aware that the company runs other programs in which financing upgrades are available to renters?
I am aware.
And specifically, are you aware of the company's electric vehicle accelerate at home, or EVAAH, offering through its transportation electrification plan?
I have not looked at the EV component of the program.
Okay, just generally, are you aware that that EVAAH program exists?
Yes.
Okay, great. And are you aware that the EVAAH offering is available to renters with owner consent?
I am aware.
Is owner consent a guardrail that could alleviate some of UCA's concerns regarding renter participation in the program?
Yeah, well, I mean, we believe that the owners should be actively involved in approving and commandeering the work, that they should be present in the signing of all documents. I think that having the owners up to speed with everything that's being done is an appropriate way to go.
Thank you. So there are potential guardrails like owner consent that could allay some of UCA's concerns regarding renter participation, correct?
I think that owner consent is a part of it. I think that the owners need to be active in approving the work and making sure that it's done in a quality way.
Okay, thank you. And now just a couple of questions about low and disadvantaged income consumers. So UCA has concerns regarding the inclusion of low income and disadvantaged income consumers in the program, right?
Correct.
And UCA recommends that the company work with low income customers to determine whether they qualify for other free programs and rebates before enrolling them in the TOBF program, right?
Yes.
UCA also recommends that the company should avoid steering customers eligible for free programs towards the TOBF program, correct?
Correct.
So in your testimony, you cited a report from the National Consumer Law Center addressing low-income customer participation in on-bill financing programs, right?
Yes.
And are UCA's recommendations consistent with those offered by the National Consumer Law Center?
They are.
Thank you. So should the commission choose to implement these recommendations, minimizing risk for low-income households, would your concerns regarding low and disadvantaged income consumers be allayed?
Yes, I think that the National Consumer Law Center basically absolutely is about protecting the interests of low income consumers. So I think if the commission addresses those or adopts those conclusions, we would be satisfied.
Thank you so much. No further questions.
Thank you, Ms. Berman. Ms. Crampton, redirect.
Thank you. Just briefly, Mr. Kirkendall, you discussed some of UCA's concerns with respect to potentially the prematurity of this application. And you heard the testimony, I'm sure, throughout the proceeding regarding the CCF contract and things of that nature. Are there other aspects of the application as it stands now that I guess are missing or that UCA would like to see before the commission can make a fulsome decision regarding this application?
Sure. I think two things that come to mind. The first is that we don't really understand how the interest rates are going to be handled in the company's proposal. The company is CCEF going to be able to change interest rates? How are they going to be changed? How are they going to? What's the process around being able to change it? They talk about the 60 to 90-day process, but that really was just something that has come up in this proceeding that we didn't know about. There's still a lot of questions regarding how the interest rates are going to be handled. I think that there needs to be some more evaluation of bill impacts in terms of how customers are going to be affected overall when considering the increase in electricity bills, considering the impacts of these loan financing issues. And is that going to result in a higher bill for customers? That's really going to be a concern for the IQ community. So there are still some things I think that need to be worked out, that need to be understood in this program.
Okay, thank you. No further questions.
Great. Thank you, Mr. Kirkendall. All right, I think we have our last witness. Mr. K.
Commissioner Plant, if I just want to let you know that we are going to waive our cross of CEO.
Okay, so I think we just have, is it UCA?
I believe staff was the only witness remaining with cross time for Mr. K.
Okay. We'll continue then. Is it afternoon? It is afternoon. Mr.
Good
K,
afternoon.
you're batting clean up here. Can you raise your right hand? And do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Is anyone communicating with you or assisting you in any way?
No.
And if that changes, you'll let us know.
Yes, I will.
All right, Ms. Vitale, your witness.
Good afternoon, Mr. K. Could you please state and spell your name for the record?
Yes, my name is Jocelyn Durkay. That first name is Jocelyn. The last name is Durkay.
By whom are you employed and in what capacity?
I'm employed by the Colorado Energy Office as the Associate Director of Regulatory Policy.
And did you cause to be filed answer testimony in this proceeding, which is marked as hearing exhibit 1000?
Yes.
Thank you. Mr. K is available for commissioner questions.
Do we have staff or did they waive?
Ms. McLaughlin just waved.
Oh, and then UCA waived as well?
I believe they waved yesterday.
Okay.
Yeah, please correct me if I'm wrong, counsel.
I'm just catching up. This may be a quick day, Ms. Duque. Really, I only had one question. I was just wondering if you are aware at all of the status of EPA's greenhouse gas grant funds for green banks. I believe CCEF had applied for some of those funds, and I know that some things were contracted, some things weren't, and there's an effort to claw back some of the money. I just didn't know where we are in terms of Colorado's status.
Yes, my understanding, which is admittedly several weeks or perhaps several months old, is that the funds are still in litigation and that they were not in the possession of CSEF.
Okay, so it's just still being litigated at this point.
That's my understanding, yes.
Okay, thank you. I don't have any further questions. I'm sorry to take your time on this. Thought we had another party. So I think that is the end of the testimony and cross-examination. Does a legal assistant have any questions about any of the exhibits in box.com?
No, I think we're good.
Okay. Anything from Commission Counsel?
Nothing at this point. Looks like we have parties who may have issues to raise at this point. I think you can get to the question of SOPs and responses to SOPs, Commissioner Plant, after maybe hearing from the parties or before, but nothing from Commission Counsel right now.
Yeah, before we get to the procedural schedules, does anyone have any other issues that we've not addressed that need to be addressed this time?
Excuse me, the company would like to re-raise one issue. Yesterday, of course, we discussed about the CCF letter, whether to come to the record or not. And Your Honor denied the entry of that letter, but also stated that you would consider it into today with your counsel. Now today we've had more sections of the letter addressed by Your Honor, Boulder, Clear, Sweep, and trial staff. In aggregate, the parties have now essentially addressed all or nearly all of the issues in the letter. The record thus has the letter's comments substantially in the record, and there's no remaining prejudice to the parties to fully move the letter into the record. If the commission does not put the letter in the record, the commission will create a somewhat tenuous evidentiary situation where your ultimate decision in this case will rely on party representations on the letter, but not the letter itself. We therefore re-raise our request to admit that letter into the record. It's not hearsay, it's not prejudicial, and we don't understand there to be persuasive reasons to continue to keep it out of the record. Thank you for your consideration.
And I did talk with counsel during the break and decided to not officially enter the letter into the record. I think we can reference it within the context of the discussions that happened in the cross, but without having anyone from CCEF available to address any questions that might come up about the contents. It would not be right to enter that into the record, and so we would deny that. I would deny that. Are there any other further issues from any of the parties? Okay, the procedural schedule right now, I want to throw out, we have SOPs due on July 31st. As we talked and discussed yesterday, and I believe the company agreed to allow a response to the issues in the SOP that are raised or the questions that are answered from CCEF that the company will include in their SOP. I would propose that the 7th, August 7th, be a deadline for those responses, and that would keep us on schedule. Does that work for the parties, or are there other suggestions? Bueller? Ms. Crampton.
Yes, can I I'm seeking some clarification on what it is that the company intends to include from CCEF in their SOP. I'm a little unclear on that from yesterday.
I think I asked them to do a number of things in their SOP as it relates to any opportunities to reduce the interest rate, particularly with the use of a loan loss reserve fund, or as I was suggesting yesterday, the possibility of creating a regulatory asset to assume the risk that might be contained within the interest rates. I think we also asked the company to get information from CCEF on what the costs of an interest rate buy down would be per percentage point, and whether or not that would just be a linear amount down to zero. There's the third thing is some clarification on when rebates are applied. If they are applied prior to financing, and thus impacting both the cost of an interest rate buy down and the cost of the monthly cost to the customer, or if they're applied after financing, in which case they wouldn't impact either of those, but they would impact the term of repayment. We need to get some clarification on that. Mr. Mansfield, I don't know if there were others that were raised around CCEF for clarification in the SOP.
I had for the company, the first two issues you mentioned, I certainly had on our list. The last one I did not have on my list, but we can add that now.
Great.
And so I appreciate that. So I guess my question is, are these 4 pieces of information that you are seeking from the company's SOP, this is information from CCEF, like whether CCF can reduce the interest rate, whether they can create a loan loss reserve? Is that what is contemplated? Is the company's including what CCF can or can't do or is willing to do in their SOP? And I say this because if the company presents that information, it could change what UCA feels, is appropriate, right? If CCF says, yes, we actually just have $100 million sitting around to buy down interest rates, that would impact probably our SOP recommendations. And so I'm not sure it makes sense for parties to write an SOP with the record we have and then get new information that's pretty substantial in terms of the issues in this proceeding and then have to respond to it.
Well, let me throw this out, and Mr. Foreman can straighten me out if I'm going off the rails. But what would the parties think of the company's SOP being due on one day, and then the party SOPs being due a certain period after that, so that you can take in the full context of the CCEF issues that are raised within the SOP prior to giving your final statement of position?
Before Commissioner Plant, before we get to that, I think it might make sense to clarify sort of what you're asking. I know you clarified kind of the information you're seeking, but I believe what you're seeking is less new information necessarily and more clarifications on the company's positions. Council understands the party's concerns regarding new information coming in, and I believe what you're requesting is for the company to clarify its positions as presented in this proceeding, rather than more so clarifications rather than bringing in new evidence, say.
Yeah, we want to clarify what so we have a fulsome record, what the actual impacts of these various different proposals might be, and would like to have the company come back with their position on that. Ms. Vitale?
I was just going to say the Energy Office supports the approach you just outlined of having kind of the company file first and then all parties file a responsive SOP a little bit later. We would just ask for perhaps a little more time. I think even Friday, August 8th instead of the 7th would be helpful, just to allow us to digest and add content to our SOPs based on what we see from the company.
Okay, Ms. King?
Thank you. We appreciate the clarification around these issues. I do have a concern with respect to the invitation for the company to, for the first time in its statement of position, advance its position on potentially creating a regulatory asset for the purpose of the loan loss reserve, if I've understood the second issue properly. CEC would have significant concerns about the creation of a regulatory asset, and that is a special regulatory tool that the company did not advance in its application. And so for your Honor and Mr. Foreman's consideration, I invite that there may be a notice challenge there by not having that information advance at all in this proceeding and having it be something of a special regulatory tool that the company has not proposed in its initial or subsequent filings. So I just wanted to flag that with respect to the regulatory asset piece. Having the information about the company's position with respect to a loan loss reserve may be welcome in a future proceeding, for purposes of a future proceeding or further consideration, but in this docket, I think that there is an issue there with respect to the creation of a regulatory asset. So I wanted to flag that for your consideration. Thank you.
Thank you. Any other, yes, Mr. Well, before we get to you, Ms. Mitchell, Mr. Hyatt.
Thank you. I guess SWEEP would share in some ways Ms. King's concern about, I think, this process. This is another example. It seems like this is an invitation to potentially have public service, despite how we might frame it, introduce new facts into evidence. And just one example of that is buying down interest rates. It's obviously been a big topic of this hearing. We had a SWEEP witness, and I think other witnesses opine on how much that may cost. And to the extent the company in its statement of position provides new cost estimates from CCEF about what it may cost, I think that puts parties at a significant disadvantage because there's no chance to cross anyone on those, no chance for witnesses to weigh in, just to have a 1 week to turn around a response to what essentially would be new data, I think is troubling. And to the extent we collectively feel the commission feels that it's improper to admit the CSEF letter into evidence that was filed shortly before this hearing, I think allowing CSEF related new information to come in after the hearing concludes to the statement of position is even, I think, more problematic for many of the parties and more prejudicial.
Any other comments before I get to Mr. Manchel to respond?
Sorry, Commissioner, I would just respond to Ms. King that I would cite her to the rebuttal testimony of Mr. Berman, who raised a regulatory asset. So I don't think there's a notice issue about addressing that topic. But I share similar concerns about this unique procedural process here, to the extent that the what's decided upon is doing this through SOPs. I would agree that allowing the company to go first and then parties respond would be appropriate, and we're fine with August 8th or 7th.
Mr. Manchel.
Thank you. Just on two issues. One is without taking a position about what this proceeding should or should not do regarding getting new information into the record, I do think that it will involve new record, not it will include new facts, I believe, not just a clarification of what we think about as a policy perspective, which is already in the record. So I do believe it'll include new information, as I understand the directions. And in terms of an SOP staggered format, we don't think it's consistent with our due process rights for us to file a pre-brief and then have no opportunity to file a reply to a subsequent response. Perhaps a better process is, if you want us to get that information into the proceeding to inform SOPs, we can make a standalone filing on it. People don't want to have a letter from CCF for some reason, but we can make that filing on their behalf, so that all parties have the same information to write their SOPs to be filed on the same day. That would be a more efficient process in our view, as well as one that's more consistent with our due process rights.
And when are you proposing that would be submitted? Just from a procedural
We have not talked to CCF about these issues, but right now, I think it's reasonable to give us and I'm saying this to allow my client to also push back on me at the same time, but I'm going to put out there July 23rd, so a week and a half, for us to file that in some fashion into this proceeding, so that everyone's on the same page to incorporate that new material, if they want to, into their SOPs.
So before I get to Ms. Crampton and Ms. King, so let's just suggest if we were to do something like that and we extended the SOP deadline just for everybody out to the next week, either the 7th or somewhere around there. We can kind of figure out what day works best. Think about whether or not that might work for you, Ms. Crampton.
I think Ms. King had her hand up first.
Oh, Ms. King. Sorry, just going by the order on my screen.
Thank you. Thank you. And without wanting to belabor the point, just so that the record is clear, while Ms. Stockmeyer is correct that Mr. Berman does indeed reference a regulatory asset in his testimony, it is with an eye towards a future filing as opposed to being effectuated as a result of this case. So Mr. Berman in his rebuttal says the company could propose a mechanism to collect such costs through a regulatory assets. And so I would stand by the initial point that consideration of recovery of costs through a regulatory asset is not part of the company's ask in this proceeding. And so would just put that for your and Mr. Foreman's consideration.
Ms. Crampton.
Yes, thank you. I appreciate what Mr. Manschultz has offered. I guess the concern is it's the same problem that we've had, which is we've had sort of backdoor CCF testimony, and now we might get post-hearing CCF testimony that isn't subject to cross-examination. We don't have a chance to respond with evidence. We can only respond in the SOP. And this is not a situation that the interveners have created. This is sort of the result of the way this case has been presented. So I will say from UCA's perspective, this feels pretty unsatisfactory. These are really critical pieces of information that are going to be inserted into the record after the conclusion of the hearing and after the close of evidence. So I know Ms. Stockmeyer, I think yesterday, had suggested maybe trying to get a CCF witness available. I don't know if that now, based on everything that has been said, makes sense, or if parties are interested in that, but I'll throw that out there.
So this is, really what it comes down to is I asked the company, I think, some questions that they don't really know exactly what the answers are to them. And so they're going to try and get the answers and then come back to us with those answers. But unless if anybody has any other questions, I'm going to ask us to take a recess of about 5 minutes, and I'll consult with counsel, and we'll reconvene at 12:30. Okay, that's what we'll do. Everybody's coming back. All right, here's what I'm gonna request. The I want to just put this within context. When the commission gave their initial order regarding this on-bill financing program, we specifically asked to get at or close to zero for low-income customers, and we asked to minimize the interest rates for other customers within various different contexts. What I would like the company to do in their 23rd filing is to clarify their position based on this record of how that might be accomplished. And following that filing on the 23rd, the SOPs from all of the parties would be due on the 8th of August. Does that work for everybody? Okay.
Can I just have 30 seconds to a minute just to make sure my client understands with myself the obligation?
Yes.
Thank you.
Thank you.
Thank you, Commissioner Plant. And I think we understand the ask, and we will endeavor to do that by the 23rd.
Great. Any other issues from any of the parties? Okay. Well, that concludes the presentation of evidence in the case. The evidentiary record is now closed. And, oh, I'm sorry.
Thanks, Commissioner Plant. I just want to make sure that I am crystal clear on what is happening. I guess in lack of better terms, the company is going to be providing a mini SOP on the 23rd, directed at the questions that you have asked of how the company would respond based on this record. And then everybody is providing their SOPs on August 7th with the rest of their arguments.
Yeah, including the company. They will provide their SOP by the 8th.
Okay.
But they will be just addressing this specific issue based on this record on the 23rd. Is that what we said? 23rd.
If I may suggest, what might be helpful is potentially putting in writing the specific questions that you're hoping that the company will address in their 23rd filing, just so the parties are aware of that in advance of reviewing the company's mini SOP, I guess, for lack of a better term, I would call it.
Okay. Is there a process, Mr. Foreman? Is there a process that I can do that with, or is there something that I need to do in order to? It's not a part of the record, right? We can still close the record.
Yes, we could issue a decision sort of setting these timelines, and but I think what would be a better way to do this is to just have the parties review the transcript. I think you were pretty clear in how you clarified your position as as you know, what you were requesting. And so I think I would encourage the parties to review the transcript from this last 15 minutes. But if you would prefer something more formalized, I think we can do that. We can accommodate that, but I don't think it's necessary here.
Ms. McLaughlin, would that, or anybody else, would that be sufficient?
I think that things might have changed in the last 15 minutes of exactly what is expected. So if possible, it would be staff's preference to have something in writing. It also would be helpful, then you can lay out the dates as well that have been changed.
Ms. Vitale?
We support Ms. McLaughlin's request and think given all the conversation we've had about a potential additional filing, it would just be helpful so we're all on the same page to have something in writing of exactly what the commission is requesting of the company in this interim filing.
Okay, we'll include that in our decision, our interim decision. Is that what it's called, Mr. Foreman?
Yes.
Something of that nature.
Yes, Commissioner.
All right. So the evidentiary record is now closed and we are adjourned. Thank you all very much for all of your work on this case. Appreciate it.
Thank you.